2 minutes late. All right. Court does call the case of the people of the state of Michigan versus Anthony Charles Holst.
Jacob Kennedy for the people, Your Honor.
Good morning, Your Honor. And there's Nazi Kyriakin-Ruli on behalf of Mr. Anthony Holston should be appearing from MDOC, Judge.
Yes, he is, and I have to start my day with you.
It's going to be a great day, Judge.
Yeah, I can feel it. Mr. Holston, can you state your name, please, sir?
Anthony Holston.
Thank you. I have before me a plea form that indicates that the defendant is going to plead to the charge of aggravated assault, the 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement, and there should be a sentencing judge waiver. Or no, what are we?
Yes, Judge.
Well, that's okay. The boxes are checked, but it's not my case. All right.
And this should be a no contest plea. Is that right, Judge? Do you have
contest? All right. Mr. Holston, can you raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth? Hope you got.
Yes, sir.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of aggravated assault. That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that?
Yes, sir.
All right. You also, do you understand what a no contest plea is, sir?
Yes.
All right. 2 things about it I have to make sure that you understand. The first thing is that it first of all means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that, sir?
Yes, sir.
All right. You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Okay.
You understand that?
Yes.
Right. Basis for the no contest plea?
lack of recollection, Your Honor.
All right. To that charge, sir, how do you plead?
No contest.
And you understand that by pleading no contest, you'll not have a trial of any kind?
Yes, sir.
All right. You had signed or had signed on your behalf an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No.
You understand that you're giving up all of those rights, including the rights contained under paragraph 5?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you in any way?
No.
You're doing this voluntarily and of your own free will?
Yes.
Court has been provided Ann Arbor Police Department report for their case number 24-61658. Any objection to the court having reviewed that report?
None from Your Honor.
From defense, Judge.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rule, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
Is counsel aware of any other promises, threats, or other inducements that have led to this plea?
No.
Your Honor.
And have I complied with the court rule?
Defense
Defense is satisfied.
Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
July 17th at 8:30.
July 17th, 2026, 8:30 before Judge Perry. Bond will continue.
Thank you, Your Honor.
Thank you. Thank you, Mr. Olson. Oh, good morning.
This morning.
Court calls the case people versus Stephen Huska. I heard what Ann,
Well, Your Honor.
I heard what Ann was saying.
Jessica McFarland requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Michael Gaddy.
Really? How is he as a supervisor?
Hmm.
Yeah, okay. Permission to practice is granted. Wow.
Brother, friend, I get that same review.
Yeah.
We have the defendant state their name.
Rahaska? Oh, they're in there doing it now. Thank you, officer. Mr. Oscar, state your name, please.
Steve Haska.
All right. And what are we doing?
We are requesting to adjourn for further negotiations with the people.
Do we have a green sheet?
Yes,
It's gonna hold it.
sorry.
Eddie, take.
No.
What is it? July 9th work.
Yes, Your Honor.
Matter will be adjourned without objection to July 9th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you. Court does call the case of the people versus Sarah McCormick.
Good morning, Your Honor. Andrew Cito, PH 74447 on behalf of defendant Sarah McCormick.
Mr. McCormick, can you unmute? State your name.
Hi there. I'm Sarah McCormick.
Thank you. All right, what are we doing?
Good morning, Judge. I spoke with the prosecutor, and me and the prosecutor have been working together, and she offered me a deal to reduce this down to a misdemeanor for controlled substance use. I haven't had the chance because we just spoke with the prosecutor yesterday. It was pretty late, and so I just need
So
to.
you did an adjournment?
Yeah, just an adjournment so I can just go over this with my client and then come back here for the conviction.
Will July 2nd work?
Yes, Your Honor.
Probable cause conference will be adjourned July 2nd, 2026, 9 a.m. Bond continued.
Thank you.
Thank you, Ms. McCormick.
Thank you.
Court calls the case, people versus Matthew Kennedy.
Good morning, Your Honor. May it please the Honorable Court, David Curtis, on behalf of many.
Her name, sir?
Matthew Kennedy.
Your Honor, we are asking for an adjournment of the probable cause conference. My client did complete Fair River and it might work into the plea, but the prosecutor needs the proof of that. So I need to get it from my client.
All right. Couple of work.
Yeah, I did want to address bond if we could just briefly.
I'll adjourn these matters to July 2nd, 2026, 9 a.m. As to bond.
Thank you, Your Honor. Judge, my client failed to appear on a date. He had called me later that day, got his dates mixed up. Tried to walk him in on a Wednesday, but he was not able to meet me at the one Wednesday. I was able to do it that day, but did complete Bear River, Judge, and he did contact me. These aren't assaultive cases. I understand the concern the court might have, but does have stable residence area, and I think he will return, Judge, based on.
So how do you come into custody?
I don't. How'd you get?
I was at work. You picked up at work.
Yeah, picked up at work.
They just came and got you?
Yeah, I didn't cut my tether off or nothing. I didn't like abscond. I didn't.
He had a tether on, Judge. I mean, yeah, it was pretty easy to find, I guess. So.
Yeah, didn't die or nothing. I kept it charged. I kept doing my weekly check-ins. I kept going.
Why was the first thing that came to your mind cutting off each other?
No, he said he didn't cut off.
No, I know he didn't say it. Well, why did that come to mind? Never mind.
Because I didn't.
It's context, Judge. That's all it is. Context.
Yeah, like I wasn't trying to go on the run. Oh, sorry.
You're good.
Anything from the people on the.
No, you're wrong.
All right. What I will do is I will reinstate the defendant's previous bond in this matter.
Thank you, Governor.
Even by. All right, thank you.
Thank you.
Hey, you know, I'm
Okay, so do you want me to change my mind or?
no, he said thank you. Governor.
Oh, I know what you said. If it doesn't go, I'm going to change my mind.
Leaving quickly.
Yes.
Court does call the case, People versus Robert Anderson.
Your Honor.
Good morning again, Your Honor. May it please this honorable court, David Burgess, on behalf of Robert Anderson, who's appearing via Zoom, Your Honor.
Hello, Robert Anderson.
Okay, thank you. All right, what do we do?
Your Honor, the people have indicated to me that there's some additional discovery we're going to have to review and obtain prior to the exam. So we're requesting another adjournment of the probable cause conference.
How much time are you going to now?
You know, this, a couple reports from YPD.
All right.
Which is fine, Your Honor.
Probable cause conference, July 2nd, 2026, 9 a.m. Bond continued.
Thank you.
Thank you. Court does call the case of the People versus Charles Johnson.
Your Honor, as well as the people.
Oh, no, on behalf of Mr. Johnson, who'll be approaching the podium and standing to my right. Mr. Johnson, once you get up here, please state your name for the record.
Was that supposed to be her case and you took it, Feltes?
Yes, Your Honor.
Lady, where are you from? Okay, don't let her do that to you. All right, go ahead. I'm sorry. Your name, sir?
Charles Bernard Johnson II.
And Your Honor, at this time, we are asking that the matter be set for exam.
Discovery is complete.
To my knowledge.
What the?
We are on June 30th.
People have their witnesses available June 30th? All right. Preliminary examination will be set June 30th, 2026, 9 a.m. before Judge Washington.
Thanks.
Bond will continue. Thank you. Court calls the case of the People versus Amanda Brown.
Your Honor.
Morning again, Your Honor. May it please the honorable court, David Burgess, on behalf of Amanda Brown, who's approaching.
Your name?
Amanda Brown.
All right, this is a waiver.
Yes, Your Honor.
Ma'am, you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. You understand that you'll not have that hearing. You'll proceed to circuit court for further proceedings.
Yes, sir.
People also waive their right?
Yes.
Yes.
Not had official offender notice as well as an agreement. My understanding that it's currently on probation to circuit court. There would be an agreement to have her at concurrent probation, no upfront jail with her parents.
That's our understanding as well, Your Honor.
Preliminary examination having been waived, defendant's bound over to circuit court on a single count. Mr. Burgess.
Waive formal reading, stand mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
August 11th at 1:30 with Judge Simpson.
August 11, 2026, 1:30.
Okay.
Bound continued.
I'll call you.
All right, I'm done.
Court calls case of People versus Douglas Hill.
Over for the people, Your Honor.
And Assistant Public Defender Zach Venue with on behalf of Mr. Hill, who approaches on the case ending in 163.
Morning, Your Honor. Jay Grant, number P58658 on behalf of Mr. Hill on 2111.
Douglas Hill. Thank you. Both of you are requesting an adjournment.
Your Honor, yes, we're trying to keep the cases together, and I believe I spoke with the prosecutor this morning, and she's still waiting on a CCTV video. And as soon as that happens, we'll set for exam.
How much time are we going to need to get that?
Spoke with the agency yesterday. They indicated that it was just processing.
It was on.
The request, they had uploaded it, but it's processing.
Got it. So a couple weeks, you think, gentlemen?
I would defer to the prosecutor, Your Honor.
Pardon?
Good, Your Honor.
All right. Probable cause conference will be adjourned to July 2nd, 2026, 9 a.m.
Thank you, Your Honor.
Bound continued. Thank you.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Morgan. Is it G-Lander?
Morning, Your Honor. May it please the honorable court, David Burgess, on behalf of Morgan Jalander.
Your name?
Morgan Jalander.
You're requesting an adjournment?
Yes, Your Honor. 2 weeks is okay, Judge.
It'll work.
I think I'm.
Probable cause conference will be adjourned July 2nd, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls case People versus Safara Kent.
Jacob Kennedy for the people, Your Honor.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Kent, who's approaching, Your Honor. State your name for the record. Steve Kent.
You're requesting an adjournment. Will 2 weeks be enough?
Would that be enough to get them?
Oh, you need,
Your Honor, I believe there's some additional charges coming.
That is correct.
So I don't know if they'll be able to get them arraigned on those, but I would think 2 weeks, depending where they are in the swear to process.
My understanding that swear to is going to take place this November. So
okay, is he then set to be, the swear to will happen, is he set to be arraigned this afternoon?
that, no, Your Honor, just swear.
Or to use it as currently. Right.
That's correct. There are 3 additional.
Gotcha. Okay. And so that this wasn't where the officer was on call.
No, but for this.
Got it. Okay, so that's where two is going to take place. He would then have on those charges. I don't. You want me to put it out 2 weeks or 3? Because here's the reason I'm asking. I don't understand if the swear to is going to happen. He's in custody. I don't know why we couldn't add him to the list to have him arraigned on those 3 charges this afternoon and then set it 2 weeks out. But if you don't want me to do that,
That's fine with us, Your Honor.
all right.
I agree. Word too about what exactly is going to happen this afternoon. That maybe they can get him on the list to be arraigned as well. Certainly.
Zach Ward's involved.
Not. No.
If he's involved, this isn't going to happen.
I'll make sure he knows that.
All right. So if the officer's going to swear it out today, we communicate with the magistrate to see if they can get him arraigned and then set it for the 2nd? So I'll adjourn this out, probable cause July 2nd, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus Dominic Brewer.
Morning, Your Honor. My name is Cook for the people.
Good morning, Your Honor. Calvert Hill on behalf of, but not with Mr. Brewer. Your Honor, it's my understanding that Mr. Brewer was picked up in Canton yesterday. Because of a hold that he had already. So I think it's my understanding, I believe he's in the Wayne County Jail or in the Canton lockup. I spoke to a family member yesterday late.
Well, we have it that, yes, he was picked up. And they filed a conditional bond violation.
Okay.
All right.
Okay. Thank you. I wasn't aware of that bond violation, so thank you for that, Your Honor.
This is the report. I think this is the Canton report that they then filed with this court, took him into custody down there.
Understood.
So at this point, what I will do though is I'll issue a bench warrant for his failure to appear. That way we can go get him. Bond will be setting him out of 10,000 cash surety.
Thank you, Judge.
You. Court does call the case of the People versus Lorenzo Murphy.
Great, Your Honor.
Good morning, Your Honor. Please, Honorable Court, David Burgess on behalf of Lorenzo Murphy. Your Honor, we're asking for an adjournment of this matter. I just got this case. I was just appointed on it.
Are you on both cases?
Yes, Your Honor.
Need 2 weeks.
Yes, Your Honor.
July 2nd, 2026. Any bond continue.
Thank you,
sir. Court calls the case of the People versus Daryl Howell.
People.
Good morning, Your Honor. Nathan Coulter requesting
Okay, permission to practice is granted.
Edward Rodriguez on behalf of Errol Howell. Your Honor, I just was appointed. The contact information is not good. I don't have an email. I'd asked for an adjournment just for purposes of contact with him. I do have an address. I did mail him a letter yesterday, but I haven't got any confirmation back. I know he's on probation, Wayne County.
He's on probation in Wayne County?
On probation in Wayne County. So in the event that I'd reach him, if the court were to adjourn it, this is the first PC.
I understand that, but I think, given the nature of the charges, I'm going to issue a bench warrant for his failure to appear.
Okay.
Bond will be set at a 10,000 cash surety.
Thank you.
We'll issue immediately. Thank you. Court does call the case, People versus Christopher Madison.
Bring it over to the people.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Madison.
In both matters.
In both matters, Your Honor.
Your name, sir?
Christopher Madison.
Thank you. You're requesting an adjournment.
Well, Your Honor, I did speak to speak to Mr. Madison yesterday. He indicated he may not want the services of the public defender anymore. So
what? He doesn't want the services of the public defender? I'm going to hire his own?
No, I
go ahead.
Do a letter and I plead guilty on all charges, sir. So I figured I didn't need a public defender to plead guilty.
Okay. Mr. Madison? Did I receive this letter? I don't think so.
Top of my head, it does not sound good.
Yeah, I don't know that I received a letter from you.
Oh.
Yeah, and why do you want to plead to 2 felonies?
Because I'm 5 years, I was under the influence of drugs.
Okay, hold on. I don't want you to, well, just listen to this, Mr. Madison. I don't want you to say anything about the charges.
Okay.
Okay. I'm just trying to figure out why you want to proceed in that fashion, but hold on a second, Mr. Bukovich.
Your Honor, as I said, I don't want my client to put anything on the record that could incriminate himself. Obviously, he cannot plead at this stage. We're at the PC stage, which you cannot plead to a felony at the PC stage because this is
you can. Yeah, I don't take the plea.
You're not going to take the plea. So ultimately, I believe at this stage, our best option would be an adjournment for us while to have time to consult with our client about the implications of a plea.
Let me ask you this, sir. If you're trying to get this done with.
Yes, sir. I'm trying.
Okay, hold on. It's not going to happen however it resolves itself. It's not going to happen less quickly or more quickly if you have an attorney, right?
Okay.
So I don't know. I think having the public defender is in your interest. The important thing, more so than it being quickly, is that all of your rights as you go through it and you go, whatever your decision is, your decision. But that to make sure that all your rights are protected. That's part of the reason that they're there and that your interest is protected. Okay. So I think what you should do, I'm going to adjourn these out a couple weeks. Okay. And then let you talk to the public defender, tell them what you want to do and talk it through with them. Okay. Fair enough. Okay. All right. I'll adjourn these to July 2nd, 2026, 9 a.m. Thank you, sir.
Thank you, Your Honor.
Court calls case, People versus Deontay Jordan.
Your Honor, bring the code to the people.
Good morning, Your Honor. J. Grant Miller, 58658 on behalf of Mr. Jordan. Your Honor, I was communicating with my client last night. He indicated having some transportation problems. He lives in Lansing. I encouraged him to get the bus down here. I would request
the whole bus thing, but go ahead.
Well, I did suggest the flyer does travel from Lansing to Ann Arbor, and then he can get the number 4 down here. Literally, I texted that to him, Your Honor. not here. I understand that people are probably going to request something.
Bench warrant will issue for defendant's failure to appear. Bond is set in amount of $10,000 cash or surety. That warrant will issue immediately.
Thank you, Your Honor.
Thank you. Court calls the case People versus Jason Smith.
Ready, Your Honor.
Morning, Your Honor. Raven Cook for the people.
Good morning, Your Honor. James Fifelski appearing on behalf of Jason Smith, who is approaching. Can you please state your name?
Jason Smith.
Thank you.
Your Honor, this is our first PCC. I'm asking for an adjournment for discovery and investigation on this, please.
July 2nd, 2026, 9 a.m. without objection.
Thank you, Your Honor.
Bond continues.
Thank you, Judge.
Court calls case People versus Janine Lebrel.
Morning, Your Honor. Raymond Cook for the people.
For the record, Your Honor, Stuart Collis on behalf of Ms. Lebrel, who is approaching and coming to my right.
Hello, your name?
Jean Lebrel.
Thank you.
Your Honor, today for PCC, we are asking for an adjournment of this matter to do some further discovery. There's some videos that we need as well as some negotiation in this matter.
Probable cause conference will be set July 9th.
Very well. Your Honor,
26,
I have a brief request on the bond. My client has to go out of state for her nephew's birthday in Columbus, Ohio. And while I am sad that
to Ohio,
I know, right?
No, go ahead.
It's late June, and she obviously will be returning back where her partner home is. But
do we have travel dates?
Yes.
Yeah, it's the last Sunday in June for my nephew's first birthday. And I'll be staying with my parents.
So the 28th?
The intention is to drive down on the Saturday and then come back the Monday.
Saturday, 27th.
So 27th to the 29th. Any objection from the people?
No, Your Honor.
All right. Her bond will continue, and you get me, you're doing it. And then I will allow her to travel to Ohio for those 3 days. Enjoy.
Thank you very much, Your Honor. See you on the 9th. Thank you.
I'm sorry, Miss Zenda. I'm really sorry that you're from Ohio. Court calls the case. People versus Wardell Smith.
On behalf of the people, Your Honor.
Morning, Your Honor. Robert G. Kill on behalf of Wardell Smith.
Much better person having been in Michigan, but
today's time for PCC.
Your name, sir?
I'm sorry. We set this for exam.
Discovery is complete.
Yeah, it's a reauthorization. Everything's the same. Yes.
All right. People have their witnesses available the 30th.
We'll do our best, Your Honor.
All right. Preliminary examination will be set for June 30th, 2026, 9 a.m. before Judge Barr.
Judge, may I make a bond argument?
May.
Judge, because this is reauthorization, the victim, who is the mother of his children, never showed the first time. That being his wife. I'm sorry, his wife. Since he's been in jail since April 21st, he's done 3 weeks of Dawn Farm program. He could do that outpatient. He's also continuing with CMH. He could do that outpatient. Done a lot of really good programs in the jail. 12-step, the DV1, DV2. I know what the prosecutor is going to say, that he called the FBI. He admits he called the FBI. He was worried about his children. After he called the FBI, his son then called him, say, Dad, everything's okay. He tried to cancel the FBI appointment. So again, it wasn't.
But that, I've heard this before. It wasn't just the call to the FBI. There were other calls that were also initiated by this defendant regarding police involvement.
Careful, what do you want to say? It was for the benefit of your children? Yeah, Judge, he did call, what, Pittsfield?
Yeah.
He did call Pittsfield. Again, it was concerned about his children, Judge. Again, there's a serious charge. We understand that, but my client could live with his mother. in Ypsilanti. She's already said it's okay for him to live there, even if it were on tether. The other issue is, Judge, and I know this really doesn't go to the case, he has a lawn business that all his equipment is in a storage area that's about to be repossessed and sold out. And we're asking the court to please consider just a reasonable bond for this man. He will stay away from the victim. And the calls he made were for the benefit of his children, who then called dad, said everything's fine so far.
Once again.
I'm going to object. While the defendant may say those were for the benefit of those children, some of those calls that involved him reporting a shooting, having law enforcement respond to that house for those children, in a sense, swatting that residence for a shooting that did not occur. Beyond that, he did call the FBI, and there were also allegations of drug use while he was out on bond. I also have concerns given in one of his calls on the 15th, he mentions, I want to know if you can help me get back in good graces with my family, that I have a child with my wife. Tell her not to cut me out of the picture. Tell her that I still love her and I need her back now. I need some support. So I have concerns that he has shown this court time and time again that he cannot follow bond and is a danger to not only the victim, but the community and law enforcement by abusing their resources and having them to respond to things that are not happening, and also harassing this victim. And I mean, at this point, it was harassed because she came back around and was on board, because she was in fear for her life because of this defendant. So I think at this point, bond is appropriate, given that he has shown this court he cannot follow the orders of the court, and is still even now attempting to try and get a hold of this victim, wanting to call her directly and having other people in his family reach out to her.
That's what I was trying to do. Judge, he said he was never trying to get a hold of the the victim. It was regarding his children. But this is the case. She never showed the first time. And again, I don't know if she's going to show the second time, but the court should.
But I've heard this bond argument before. I mean, I don't know of any circumstances that have changed from the court's perspective. It's actually gotten worse, quite frankly.
A reasonable bond to protect society.
I think the bond is reasonable. Motion denied. Court calls case, the people versus Tariq Wilson.
People.
Assistant Public Defender Nick Bukovich on behalf of Mr. Wilson.
Mr. Wilson, is there somebody you can ask to help unmute? Good morning.
All right.
Thank you.
Welcome.
Thank you. Mr. Wilson, can you state your name, please, sir?
Eric Wilson.
Thank you. You're asking for an adjournment.
Yes, Your Honor, I filled out the visit application. I'm just waiting for a response. So
How fast do you typically respond? Do you know?
well, they told me it would take 2 days to process that, but apparently that may not have been true because I sent it more than 2 days ago.
All right, he's in MDOC.
Yes, he is.
I think the court's familiar with that as mine, and it could take weeks.
Yeah. All right, let me adjourn this out to July 16. Well, in effect, defendant custody status, July 16, 2026, 90.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Court calls the case of the people versus Natasha Brazelton.
Morning, Your Honor. Raymond Cook for the people.
And Assistant Public Defender Nick Bukovich on behalf of Ms. Brazelton. Should be appearing via Zoom.
Not checked in.
Yeah, I did speak to Ms. Brazelton this week. We were playing a little bit of phone tag. We do have a finalized offer, so I cannot explain her lack of appearance here today. However, I did speak to her this week, so I would be requesting an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount $10,000 cash surety. Court calls the case People versus Lowry Shinavar.
Thanks, Bill, for the people.
Good morning, Your Honor. Sam Bernstein with and on behalf of Kevin Genevar Lowry.
Yes, it is. I'm sorry.
Kevin William Shinavar Lowry Jr.
Your Honor, we're hoping for an adjournment to review discovery.
Today. All right. How much time? 2 weeks be enough for it?
I think so, Your Honor. Yes.
Will be adjourned to July 2nd. Bond continue.
Thank you, Your Honor.
Court calls the case People versus Austin Bird.
Hello.
Morning, Your Honor.
Oh, here we go.
Wagaga requesting permission to practice pursuant to Michigan Court Rule .120 under the supervision of Assistant Public Defender Nick Bukovich on behalf of Mr. Bird.
Permission to practice is granted. Sir, state your name. Mr. Bird?
Yes, Your
Can
Honor.
you state your?
Austin Bird.
Thank you. All right, what are we doing?
We're just requesting an adjournment for ongoing plea negotiations, Your Honor.
Adjourn this matter to July 16, 2026, 9 a.m.
Your Honor.
Bond continue.
Your Honor. Thank you.
Court calls the case People versus Ayad Abulez.
Bill, for the people, Your Honor.
Morning, Your Honor. Assistant Public Defender Davi Lebo on behalf of Mr. Abuelas. Mr. Abuelas, can you tell the court your name, sir?
Iyad Abuelas. Good morning, Your Honor.
All right, what are we doing?
Andrew, I've been requesting to adjourn both matters for discovery, and I would like to address bond as well.
Probable cause conference, 2 weeks or you want 3?
I would ask for 2 weeks, Your Honor.
July 2nd, 2026, 9 a.m. Go ahead, Esteban.
Thank you. With regard to bond, Mr. Abuelas has told me that he has stable housing located in Ypsilanti. He does indicate to me that he has some health issues, needs a medical appointment with regard to that next week, as well as an appointment with a psychiatrist he's going to be needing to reschedule as it all is being custody today. He also indicates to me that he has 2 children, a 1-year-old and a 3-year-old, and he's quite anxious of being separated from them, and he anticipates they feel the same way. They're currently staying at home with his wife. If we have no objection to home confinement tether, and Mr. Boyles indicates to me that he could post up to $1,000 in bonds, so we'd ask
how much?
Up to $1,000, Your Honor. And so we'd ask the court to consider a personal bond or in the alternative, a 10% bond that Mr. Boyles will be able to post.
Response.
My understanding that the defendant was just remained on new charges yesterday. And
yes,
criminal history. If the court was inclined to release him, we would also be asking for it. Okay.
Well, he lives in Ypsi.
Does, Your Honor. And he has provided me with an address that I can provide to the court.
Given that argument, the court will modify the defendant's bond to a $10,000 10% bond. Defendant must be placed on a GPS home confinement tether prior to his release.
Thank you, Your Honor.
Yeah. Thank you. Court calls case, People versus LaShawn Charles.
Your Honor, agreement.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Charles, Your Honor. She is
Good
on Zoom.
morning.
Judge.
Good morning. Your name?
LaShawn Charles.
All right, what are we doing?
Your Honor, I'm asking for a brief adjournment. There is an ancillary issue that I really want to clear up. The people have made an offer. I just want to confirm that everything is good in that way. I'm going to have Ms. Charles speak with someone in my office with expertise on this issue.
During it July 9, 2026, 9 a.m. bond continue.
Thank you, Your Honor.
You need a green sheet.
Oh, I'm sorry, Judge. I have it. I may approach.
Court does call the case of the People versus Wesley Brand.
This is through to Michigan Court Rule 85101. First, prosecuting attorney action.
Permission to practice is granted.
Your Honor.
This is Public Defender Davi Lebo from Mr. Brand. Mr. Brand, please state your name.
Wesley Brand.
And Your Honor, Mr. Brand will be waiving. I reviewed the waiver form that he has just executed at here at the podium.
So you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged or the offense alleged was committed and that you committed it? Yes. You understand you'll not have that hearing. You'll proceed to circuit court for further resolution? Yes. We'll also waive the right. Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Your Honor, we acknowledge receipt of information. We waive formal readings and stand mute at this time.
Defendant every way formal reading standing mute. Court will enter not guilty plea. Pretrial will be set for
My second at 1:30 for Judge Slay.
July 2nd, 2026, 1:30, Judge Slay.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, bound continue. Court calls case of the People versus Aaron Davis.
Haley Glenn on behalf of the people. Yeah.
Assistant Public Defender Zach Vinny on behalf of Mr. Davis, present via Zoom. Sir, can you please state your name for the record?
Wow. Okay, that's it.
Aaron Michael Davis.
Oh, there we go. Okay, thank you, sir.
Your Honor, we would set to examine this matter.
You need an exam.
Yes.
And he is located where?
It's the new path in Flint, I believe, Your Honor.
Century.
Yes, Your Honor.
Okay. I'll set it for exam. Is he going to be permitted to lead treatment?
Oh, well, I had a discussion with him yesterday or yesterday, the day before, and I believe he stated that he would be able to be transported here for the exam.
Okay. Is that correct, sir?
Yes, Your Honor.
Okay. Do you know about how much time they might need to try to make that happen?
2 weeks, Your Honor.
So they can't do it in 12 days. I can either do it in 12 days or 19 days.
12 days. The guy's with me. My care coordinator is with me right now as we speak. He said 12 days is fine, Your Honor.
Okay, so we can do the 30th?
Yes, sir.
All right. Then, and discovery is complete?
To our knowledge.
People have their witnesses available the 30th? All right. Preliminary examination will be set for June 30th, 2026, 9 a.m. That's before Judge
Washington.
Judge Washington.
Thank you. God bless him.
Take care.
Okay,
Thank you, Your Honor.
Court does call the case of the People versus Maurice Robinson.
No for the people, Your Honor.
Studies in.
Julie Gaines, Senior Assistant Public Defender representing Mr. Robinson. Yeah.
Okay. Sir, can you state your name, please?
Please, Robinson.
All right.
Yeah, Mr. Robinson is in custody in Illinois, I believe. I was able,
Sebago County. Yep.
if I was able to schedule an appointment to meet with him on June 23rd, I'd ask for a PCC day after that day.
Okay. But we're gonna need at least 2 weeks. How? All right. You've got an appointment with him on the 23rd.
That's correct, sir.
All right. So what I'll do so that we can have enough time for a read, if they'll honor it, is probable cause conference will be adjourned then to July 9th, 2026, 9 a.m. Bond, thank you.
Thank you, Your Honor.
Thank you, sir.
I'll see you by Zoom on 23rd, sir.
Court calls case People versus Grant. Jay.
Morning, Your Honor, people.
Morning, Your Honor. Michael Gaddy, Assistant Public Defender on behalf of the.
Your name?
Grant Matthew Duche.
What are we doing?
Grant, we'd like to set this matter for.
Like to do what?
Set this matter for exam, Judge.
Discovery is complete.
Yes, Judge.
Would people have their witnesses available the 30th?
Yes, Your Honor.
All right. Preliminary examination, June 30th, 2026, 9 a.m. before Judge Barr.
Thank you, Judge.
Thank you. Court calls case People versus Xavier Bonnet.
Your Honor,
Your Honor, Peter Winter on behalf of, I'm standing in for Mr. Amadeo, Your Honor.
All right.
State your name for the record, please.
Xavier Bonnet. What are we doing?
Your Honor, I'd like to ask that the PCC be set over to the 9th. I also understand there's a probation violation because he didn't get tested. I've talked to him.
It's not only that he didn't get tested, he didn't even report. I wasn't aware.
I don't know that Mr. Amadeo was his attorney at that time, Your Honor. I have made sure that he's going to. His mother is here with him today, and I'd like to adjourn the violation over to the 9th. I've made very clear to him that he's got to report this morning.
When he was arraigned, he was told to go over.
Well, I was not present. I'm just indicating to the court that I've told him very emphatically his mother is here. He's going this morning.
Okay, is he saying he didn't know? Is that what he's representing to the court? Because he needs to be careful if that's what he's representing.
I don't understand.
I did.
Tell the judge.
I didn't understand. Prepare new orders. Is he working? What are you doing when you're out? I work at McDonald's.
Well, who else?
How long have you worked there? For like 5 months.
He lives with his mother and I believe his sister, Your Honor, and they're both here in the courtroom. His mother's here in the courtroom with him.
We'll prepare a new order for community corrections. You need to go over there before you leave this complex. You understand that? Understand. And so I want that order and an order for a GPS tracking location, Tepe. And then I will adjourn this to July 9th, 2026, 9 a.m.
I'm sorry, I didn't hear when, Your Honor.
The 9th.
Thank you, Your Honor.
9 a.m. Bond continued with those added conditions.
Thank you, Your Honor.
Court calls the case, People versus Maisha Gaines.
Read the notes for the people, Your Honor.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender representing Maisha Gaines, who's approaching. Would you please state your name?
Maisha Gaines. I'm presuming no relation.
No, you're not.
Okay, all right, go ahead.
Your Honor, we have come to.
This work, it's amazing. Go ahead.
Your Honor, we have come to a resolution in this matter, but need some additional time to effectuate it. It's a global resolution with a case in the 14B District Court.
All right. So does she need to get there first or?
Yes, Your Honor. She's currently scheduled, I wanted to say, for June 30th for a pretrial there, but we are trying to get an earlier date for her there. The attorneys and paralegal over there working that day.
All right, but you might get the 23rd if it's an early. Why don't I just do this? July 2nd, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you. Court calls case People versus Terrence Hall.
Alexander, on behalf of the people, Your Honor.
What is Bellinger doing? Who? Where is?
I think we withdrew from this. Good morning, Mr.
Hey, how you doing?
Yeah.
Mr. Winter, is this your case? Are you're here for Mr. Amadeo?
I am, Your Honor.
All right, this is another one of his.
State your name for the record, please.
Terrence Hall. All right.
Mr. Amadeo was appointed on this case about 5 days ago. He hasn't had a chance to speak to Mr. Hall because he was bonded out. He's tried to visit him in jail and he bonded out. So we would request this be put over to the 9th.
Any objection from the people? Probable cause conference adjourned July 9th, 2026. 9 a.m. bond continued.
Thank you, Your Honor.
Here. Court calls the cases of the People versus Taiwan Grigg.
As follows for the people.
Who's this?
I still progress on 2024 case.
Corrected.
Joy Gaines, Assistant Public Defender representing Mr. Griggs. She got going.
Okay.
Stephanie Cannon on behalf of Mr. Griggs, Your Honor. Thank you, Joy. Your Honor, we are asking for did Mr. Griggs already say his name?
Mr. Griggs, apologize.
Thank you. We are asking that the 2025 case be adjourned because additional discovery has been requested. We're asking that the 2024 matter be set for preliminary exam.
However, I don't have a problem doing that. However, I don't have questioned, I believe, twice, not 3 times, the corrected order on the 24 case.
And my apologies, Your Honor, because I thought I had given that to the court. If I have not, I will resend it.
I don't know if
The correct one I received. It's one that was incorrect twice, and then I received one for the wrong case.
Your Honor, I will revise them and resend them again. I thought Ann and I thought I had fixed them, so it
that didn't
addressed.
did
Not work out well, but I will try again.
I'm not going to keep waiting on this order. I'm going to ask the jail if we can take him back.
And we'll do it.
In order, then I'll bring it out. I'll be able to sign the order. Then everything will be in place since we've asked for it numerous times.
No. Come back and we'll ask them.
Thank you.
We're coming right back. We're coming right back.
Yeah. Court calls the case, People versus Hetty Dick Diaz.
Assistant Public Defender Davi Liba for Ms. Diaz, who I am hoping is appearing on Zoom. Your Honor, I have been attempting to.
Brings eternal, but go ahead.
It does, Your Honor. Brett's not here. I've been trying to reach her for the past few days and I have not been successful in doing that. I have generally been able to in the past, so I am surprised and would ask for an adjournment.
Bench warrant will issue for defendant's failure to appear, bond 10,000, cash share.
Thank you, Your Honor.
Or cause case versus Amanda James.
And the bill for the people, right?
Assistant Public Defender's Committee with on behalf of Mr. James approaches.
You guys got to make sure to clear that way when transport's coming through, Mr. Levo.
Ms. James, can you state your name for the record?
Amanda James.
Thank you.
Your Honor, this is the intent set for a bond hearing. Ms. James, as you remember, as you recall last week, Ms. James was ordered to go to community corrections to test. She did go to community corrections to test. However, she does admit that she did not go straight there. She had to go home first. She went home to get the money to test, and then her mom wanted to stop at Burger King because she was hungry, so they stopped at Burger King. Then they did go to community corrections to test, but by that point, the no bond order was already in, so she was arrested from there.
Oh yeah, I remember. Did we didn't get a test, did we? It was positive, right? Yeah. Okay, so I told her to go to community corrections.
And did.
She's here on campus. She left the building and I remember her walking out. She said, I'm going over. We sent another person slightly after her who got over there, tested, came back. We still hadn't heard from Miss James.
Ms. James indicated that her mom is here and does have the receipt of her going to community corrections the same day.
Oh yeah, I know, but it was like she was supposed to go there and come back.
Yeah. Ms. James indicated that she did not, at the time that she was here today, or last week, she did not have the money to test, so she had to go home first to get the money, and then had to go to Burger King.
Where does she live?
1282 Medford Drive, Huron Heights.
So in this county?
Yes.
So when does it 4 hours or 2 hours to go home, come back,
3 hours,
and then do that? And I don't know where the Burger King comes in.
It was not 3 hours, Your Honor. I was going 45 minutes.
Yeah.
I have my test.
For me that.
Please,
because we called over.
She said she called you when I got there, and I sat for like.
I know. She did.
Oh,
but she did get over and test.
She did come. Yeah.
Yeah. Then she left.
I did.
Then she, what, Your Honor, I apologize.
Then she left. She didn't come back over.
They arrested me there.
Yeah, I know. Why? Because we had
Said you put
warrant.
the warrant out. Yeah.
Yeah. And she tested positive for cocaine.
As I said, I possibly would. That was why you tested. That's why you said.
That is not what she said.
Your Honor, I told my probation officer that there was.
Oh my!
You recall?
Not what you said. Told me.
Your Honor,
I've not talked. I'd turn around like that. I'm done. I'm done. Her bond remains denied. How much time do you want to put it over? I'm not playing games. I am not playing.
I apologize.
Think I am if you're going to turn around and start smiling and doing all that. This is not a game.
I was just
bond denied. I'll set it over to July 2nd.
You're not even doing my information properly.
Keep talking. You want your case now, Ballinger? Court calls case, People versus Nicholas Dragos.
Positive evil. We're gonna go on behalf of Mr. Draco.
Contract. What's that for?
Did you want to say anything or no? What were you gonna do?
I was waiting for your,
You can stare at that screen all day. That's not gonna happen.
I was sorry, I was waiting on your cue, Your Honor.
You were waiting on my cue?
Yeah, I thought,
What?
usually you say, what are we doing? But I didn't know if that was.
Oh, okay, all right. Okay, so you need a cue.
Well,
All right. We can.
I didn't want to interrupt you.
What are we doing?
We were going to request an adjournment.
We're gonna be the same thing because your client's not here.
Right.
Yeah.
We were just going to mention there's an intensive amount of discovery, but he's not here. So I guess my request for an adjournment might be irrelevant.
I will say.
You can make the request.
I will say.
Nick, why are you trying to save him?
Because he will save me in the past, Your Honor. Public Defender Nick Bukovich on behalf of Mr. Dracos. I will say Ms. Gaines and I had a very intensive conversation with him yesterday about this matter. So I am confused about his failure to appear today. So I would ask the court to consider an adjournment. This is a case of a very intensive amount of discovery, over 954 pieces of media on Axon to review. So I would ask the court.
You're requesting an adjournment?
Yes.
He said it was irrelevant.
My mistake, Your Honor.
I would be, for the record, I would be requesting an adjournment.
Really wouldn't matter. I'm gonna issue a bench warrant. People's requested bench warrant, bond 10,000 cash surety. Warrant will issue immediately.
Thank you.
I'll remember next time. Give him the cue. Court calls case versus Daniel Keener.
Is that on behalf of the people, Your Honor?
Assistant Public Defender Davi Lebo for Mr. Keener. Mr. Keener, can you state your name, sir?
Daniel Keener.
Thank you.
And Your Honor, we did just receive some additional discovery on this matter towards the end of the day yesterday. I'd be asking for a brief adjournment to review that and also would like to address bond.
PC will be adjourned July 2nd, 2026, 9 a.m. As to bond.
Thank you, Your Honor. With regard to bond, I did have a chance to review the calls, and it is my understanding that the calls do relate solely to Mr. Keener getting his property back and having his brother pick up that property. He understands now the proper way to do that was to call the police, ask the police to arrive there first, and only obtain his property with the police present for a civil standby. He now understands this. He knows the seriousness, no contact order. He knows it violates the court to reinstate his previous bond.
Respond.
Your Honor, I leave this in the discretion part. I do want to know that I understand the calls, but I also would like to know that the defendant was not very honest with the court about what the contents of those calls were. And then one of those, or two of those calls, were one was a completed to the victim, her number, after he was told not to have contact with her. While it was a short call, I do have concerns that he called her after he was told not to call, and then also called someone else to get in contact with the victim, identifying her by name. So I do have concerns, and I know he was remanded last week by the court. If he is released, I would ask him to be on home confinement, because given his bond violations in custody, I would have concern about bond violation out of custody. But I'm going to have to
Tell you no contact, right? And I don't know, and I'm unclear that his reasoning for why he says he's contacting, I don't buy it. I mean, I think it's clear. Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Court calls case People versus Lance Ford.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Ford. Would you please state your name for the record?
Lance Ford. Thank you.
Your Honor, we are continuing negotiations for this matter and would ask for an adjournment.
Without objection, July 9th, 2026, 9 a.m.
Thank you.
Thank you. Court calls case People versus Crystal Lewis.
Assistant Public Defender Zach Cunha with on behalf of Ms. Lewis, who approaches. Lewis, can you please state your name?
Crystal Lewis.
Your Honor, we're seeking an adjournment for the negotiation. Well, and then I would ask to be heard on bond as well.
Matter will be adjourned July 2nd, 2026, 9 a.m. Esteban.
As the bond, Your Honor, so Ms. Lewis is currently on a $10,000 10% bond, which is not a bond that she can post. She does have a stable place to live. She lives locally in Ypsilanti. She does also provide home health care for her long partner's mom, Your Honor, as well. She on June 11th, her long-term partner had a serious heart surgery, and she has been unable to see him or check in with him or see how he's doing or help him out. She has two daughters at home, an 11-year-old and a 19-year-old. Wait, is your 11-year-old a daughter or son?
Son.
Oh, sorry. I apologize, Your Honor. An 11-year-old son and a 19-year-old daughter. She will wear a tether if necessary. She will drug test if necessary. She'll do what she has to do. So she is asking for consideration of a personal recognizance bond so that she can, be out and help support her family. And then also, lastly, Your Honor, it is her birthday next week. She'll be turning 49 years old, and she would prefer to spend that with her loved ones.
I hear they have good cake at the jail. Response from the people?
Your Honor, I see that she has a bench warrant out of the 44th Circuit Court of Powell. I also see that she would appear for a motion to carry.
A motion hearing?
That's what my notes said. Failure to appear for a motion.
What's the bench warrant out of how?
If I get one moment.
Yes. Yes.
I also see consumption for you.
And does it give a bond?
Bond.
So it would be useless for me to release her because she'd be going to Howell.
If you were his chair, you'd be going to Howell anyway. So you'd still.
Motion for bond reduction denied. Bond will continue.
Your Honor.
Yeah. Court does call the case of the people versus Stefan Wainwright.
The nine people, Your Honor.
Assistant Public Defender Duffy, Lebo form, Mr. Wainwright.
Mr. Wainwright?
Yeah, they're going to get the keys to open this food slot.
Okay, thank you, sir.
Your Honor, we do still have some competency concerns. We're going to be seeking independent evaluation. We have begun reaching out to experts for that purpose. We're hoping to find one who can do it a little bit sooner than the date we were given.
Do what?
An independent evaluation, Your Honor.
So say that again, Mr. Lebo. You're trying to get the independent evaluation.
Yes, Your Honor.
You're trying to do it sooner?
So we've reached out to one expert who could potentially do it. He's given us a day of after Labor Day. We're hoping to find someone who can do it sooner than that.
So I'm trying to get released. So if you can do a personal recognizance, we can speed this process up so you can stop bullshitting yourself. So now that you understand that, if you don't release me on a personal recognizance, there's really nothing much to talk about at this point. So it's your decision.
Alrighty then.
Because he's not my attorney. I'll pay for that. I have plenty currency. That's not a problem. But if you guys would like to meet in person, be much better. So I actually have a meeting to go to. I'm a little busy. So let me know. They'll let me know up front. What's your name? Samson? Okay, let me know. And then once you do that, it can be in person. I have a couple clients that I have to take care of right now.
I'll meet with anybody. I don't mind. All right.
He was in person yesterday.
Dependent.
Yes, Your Honor.
I think so. This was set, his competency, I adjourned his competency hearing to the 18th.
Yes.
You need that adjourned out because you're trying to get the independent.
Exactly, Your Honor. Thank you.
All right. Give me a date in August. Set it now. I'll adjourn it out to August 6, 2026, 9 a.m. bond at this point, there we go. Thank you. Thank you, sir. What? No, don't. I'm Samson. Yeah. No. Court calls the case, People versus Kalani Franklin.
Morning, Your Honor. Raymond Cook, the people.
And good morning, Your Honor. This is Advocate Ruby. On behalf of Ms. Kalani Franklin Coachman. Kalani, state your name for the record.
Kalani Franklin. You're welcome.
Kind of the court.
I have a plea form in front of me. Plea form indicates that. Okay, I guess the added count too is retail fraud third.
Third degree, yes, Your Honor.
All right, the 93-day. Upon her successful plea to that charge, count one would be dismissed. There is an agreement, or prosecutor will recommend sentence under Hyde.
Yes.
That's the court's full understanding.
That's correct, Your Honor.
Yes. And Ms. Franklin is prepared to enter that.
All right, may I have her sworn?
You telling me swearing that I'm about to get the whole truth, nothing but the truth.
Can counsel approach, please?
Good morning, ma'am. Your name? You are charged with a civil infraction of having a dog without a leash and violation of the general animal care ordinance. You have the right to an attorney. If you would like one, I will give you one.
Okay.
Would you like an attorney? You want a lawyer?
Yes.
Okay. You go out in the hallway. I will give you an attorney and you're all set, okay? Thank you. Johnson, Virginia Marie Johnson, 26G306744. Mr. Lechner.
Good morning, Your Honor.
Your name?
Virginia Johnson.
Ma'am, you're charged with operating while intoxicated. You have the right to an attorney. Do you want a lawyer? Okay. You go out in the hallway. I will give you that and we'll go from there. Thank you. Zachary Ryan Taylor, 263-07077. Sergeant, your name?
Sergeant Gary Robinson.
Come on up here, Mr. Taylor. I just don't want to take your name. You know, I don't want to take this if there's there's a minor complaint. I just don't. I don't mind if you give them a 1 point if it was really minor. If the person didn't get transported to the hospital, didn't go to.
Yeah, I don't see any of that. It was listed as a minor crash, minor damage to both, and a complaint of neck pain for the driver.
So I don't mind if you give them a 1 pointer, but I don't feel comfortable.
Maybe like 1 to 5.
You can do that.
Okay.
Can do
Yeah,
that.
can I do that?
I'll hand that back to you.
Okay.
Mr. Taylor, go see him and you'll come back in. Thanks. People against Bobian. What do you have, Mr. Schloff and Mr. Lechner?
I have Mullins, I have Cannon, and I have another gentleman.
Mr. Lechner?
Brett Pruitt, your honor.
I don't have that file, I don't think.
Keep them all there.
Okay, Mr. James Jordan Bobian, 263-06840. Your name, sir?
James Bobian.
You're charged with disorderly places. You have the right to an attorney. Would you like one?
Yes, your honor.
Okay, so you go out in the hallway. They're going to be backed up, so just be patient, okay?
Okay, thank you.
And we'll give you a lawyer and you can talk to the lawyer and then you can come in with your lawyer. Thank you. People against Howard. Is that yours, Mr.
No.
Which one did you say? Mullins, I'm sorry, Mullins. Heather Rochelle Mullins. 26648-760. Steve, there's only one file.
Good morning, Your Honor. Director James Schroff. Ms. Mullins called up to the courthouse earlier this morning. She is ill and she's asking for an adjournment.
All right, we'll give her an adjournment. What do you have for me?
That'll be July 2nd at 8:45.
July 2nd at 8:45, okay?
Thank you.
Thank you. I don't have your other ones in front of me. I'll have to dig those out. Sir, with the iPhone, and it looks like you're in a vehicle with a red cab, I think. Can you please tell us who you are, or I'm gonna have to have you,
I've tried to chat with him, Judge. I'm wondering if he is that victim Jessica told me that you wanted in.
well, he's got to tell us who he is the problem.
Of Floyd Simpson.
Yep, okay,
Just wait a
that's it
second.
then.
Okay, we've been calling you and you
Yeah,
gotta
I didn't have audio at first.
Okay, good enough. Just give me a minute and I'll get with you, okay? I want to ask you some questions on that. I asked him to call you this morning. Aaron
Okay.
Kennard, 25G306491. All right. Ma'am, your name? I'm going to go ahead and arraign you on this charge. I'll explain the charge and the possible penalties, and then we will go from there. You are charged with failure to attend the Retail Fraud and Economic Crime Prevention Program with Class A Training Center. That's count one. Count two is that you failed to pay your fines and costs as ordered. Do you understand both of the charges?
Yeah.
You have 8 prior technical violations. This would be 10. If you plead guilty, you could be incarcerated on this for up to 90 days. Do you understand that?
Yes.
And did you sign, read, and understand an advice of rights form this morning?
Yes.
You are presumed innocent. They have to prove you guilty by a preponderance of the evidence. You have the right to remain silent. You have the right to question their witnesses, to bring in your own, to use your subpoena powers to the court to bring in those witnesses. If you plead guilty, you're giving up all those rights, and there will not be a hearing or a trial of any kind. You understand that?
Yeah.
All right. Who has the phone?
Got that phone.
It's got to go. Out of the building. You have the right to a lawyer, ma'am. I'll be happy to give you one at public expense. Would you like one?
No, thank you.
I think you need one. Let me get you one. Ma'am, let me get you one. Let me get you a lawyer, okay? I'll enter a not guilty plea for you. I mean, you got 8 prior technical violations, so I'm gonna get you a lawyer, and you will come back in here with your lawyer as soon as you talk to the lawyer. Just be patient, okay? All right, thank you. Howard, Ramel Lavertis Howard, 25W838526. Your name, sir.
Now, how are you?
Good morning to you. You are charged with a violation of probation. I placed you on probation on October 1 of 25. I have 2 counts here. It is alleged that you failed to pay fines and costs as ordered. You have a balance allegedly of $545. That's count 1. Do you understand the charge? Count 2, that you failed to provide proof of completing 30 hours of community service by May 1 of 26. Do you understand the charge? You have 3 prior technical violations here. So if you plead guilty, your probation could be revoked and you could be incarcerated for up to 90 days. Do you understand that?
Yes.
All right. Did you sign, read, and understand the advice of rights form here today?
Yes.
If you plead guilty, you'll be giving up all those rights and we're not going to have a hearing or a trial. Do you understand that?
Yes.
All right. You do have the right to a lawyer. I'll be happy to provide you with one at public expense. Do you understand that?
Yes.
Would you like a lawyer? You might as well get one. Let me give you one, okay? I'll enter a not guilty plea. There's nothing to be scared about, but I do think with 3 prior technical violations, you're going to need one, okay? So go out in the hallway. We'll give you a lawyer. The lawyer will speak with you, and then you'll come back in here, okay? Thank you very much. There we go. Brett Lee Pruitt, 26G82588A C 26G82589A B C and 26G82590.
Morning, Your Honor. Attorney David Leckner, number 67994, out of Bradley Field, who stands to my left. The privilege is arraignment with formal reading information and support stands for each matter pleaded not guilty to be done.
Sure, your name?
Brett Pruitt.
All right. I have not looked at the file, obviously. I just called it. Can you tell me what the nature of these allegations are, Mr. Leckner?
Your Honor, they seem to be blatant allegations. However, Mr. Pruitt is addressing a number of them already prior to showing up to it today. So I have no doubt that the ones these were addressed completed and the others that he hasn't forgotten to address yet, he will address them quickly.
All right.
It's long and we're trying to work this out.
All right, let me go ahead and enter a guilty pleas for you, sir. All right. I'll do that on all of these, including the failure to respond to municipal civil infraction. I'm going to give you $1,000 personal bond. You cannot leave the state without the consent of the court to violate a law. You must appear in court as directed. We're going to give you another court date. I'd strongly encourage you to take care of everything here. Okay, sir? What do you have for me, Heather?
July 2nd at 8:30.
Good with you, Mr. Lucky?
We get some more time. So this is the first round until we get.
Am I here July 16th? I am, am I not?
Let's see, we have, yes, July 16th, you are here.
Can we do 8:30 on July 16th?
We sure can.
That's great. Thank you.
All right, so sir, you got to make sure you take care of everything, okay? All right, so that's what we'll do. We'll give you July the 16th at 8:30 in the morning, and we will go from there, okay? Anything else, Mr. Lechner?
Oh, Your Honor.
Have a good day, sir. You can go down the hall, get your notice, and it's a paper notice to take with you and put in your calendar, okay? Best of luck. Thanks.
Thank you.
Did you say you have Thornsberry? Johnny Luke Thornsberry. My court office will be right back if you'll stay right there, okay? 25W839358. Come on up, Mr. Thornsberry. Your name, sir? All right, you have a violation of probation. They think that you did violate probation in a couple of different aspects. Actually, 3 different aspects. Count 1 alleges that you failed to refrain from consuming alcohol or drugs testing positive for cocaine on May 26. Do you understand the charge? Count 2. And it says the test was also positive for fentanyl, but the defendant did not pay for the lab confirmation. I just want you to be aware of that. Count 2, failure to refrain from consuming alcohol or drugs testing positive for cocaine on May 17 of 26. Do you understand that charge, sir? Yes. Count 3, that you failed to refrain from consuming alcohol or drugs testing positive for amphetamines on June 4 of 26. Do you understand the charge? Yeah. If you plead guilty or if you're found guilty, you could have, these would be 3 technical violations. You have 5 prior technical violations. You could receive 90 days in jail on each. Do you understand? Yeah. I can't hear you. Yeah. And did you sign? I'm not keeping you up, am I?
I just got over in one time.
You want to sit down? Did you sign, read, and understand the advice of rights? Yeah. If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that? Yeah. You do have the right to a lawyer. I'll be happy to provide you with one at public expense if you would like one. Would you like an attorney? Yeah. All right, we'll give you one now, okay? You feel up to handling this today? Do you feel up to handling this today? Okay. We'll give you a defense lawyer, go out in the hallway, you'll meet with him or her, and then you'll come back in front of me, okay? Thank you. Mr. Simpson, I do want to hear from you. This is court-appointed lawyers. Do I have, who's your lawyer again, Mr. Gannon?
It's, he was just sitting right here.
Mr. Schwab.
He told me to run out and grab him.
If he's ready, I'm ready.
Yes.
Oh, yeah. Give me 1 second, Mr. Simpson, okay?
Okay.
Z-Force Transportation, Inc., 260-150-9898.
Good morning, Your Honor. Paul Robinson, P number 39327 for Z-Force Transportation.
I also have a B file here. Okay, so you guys couldn't resolve this today?
We have an offer that I can recommend to my client, but the decision maker at my client's office is on vacation. So I just asked for an adjournment to get official approval of the offer.
What's the day we can do, Heather?
We could do this one, it's Brownstown. We could do July 1st.
You good on that day?
I'm actually going to be on a plane to Chicago for the Elks National Convention for that whole week.
Okay, then we could do, our next Brownstown date is July 15th.
That's good.
8:30, July 15th, okay? July 15th at 8:30. All right, have a good time in Chicago.
Thank you. Take care.
See ya.
Bye.
All right, so that's A and B. Okay, now. I did have them contact the victim. I just want you to be aware, and he is here. James Dean Gannon Jr., 26B150416, B and C. Okay, I'm going to come back to you, Mr. Flint Simpson. Stay right there. Counsel, your appearance.
James Schloff, 30720. Together, Mr. Gannon.
Mr. Gannon, your name?
James Dean Gannon Jr.
Mr. Simpson, your name, sir?
Floyd Simpson.
All right, so I have here defendant in the defense and the prosecutor met and reached an agreement on May the 6th. There's a possession of a controlled substance charge here, and there is a charge of larceny from an automobile that was pled down to attempted larceny from an automobile. So he pled his charge on the attempted larceny from an automobile under a local ordinance, which is punishable by up to 45 days. He pled guilty to possession of a controlled substance under a statute which will enable him to have that case dismissed if he is compliant with all terms and conditions of probation. Did you get an opportunity, counsel, to review the victim's statement on this?
No.
I'm going to read it to you.
Okay, go ahead. I was just about to say, I did go over the.
Right. This is what it says. My name is Floyd Simpson. I rent a lot on Trentwood Court, Brownstown, to park my semi-truck. The plaintiff, James Dean Gannon Jr., was apprehended removing items from this property without my permission. Among the items were tools and equipment that were used for my truck maintenance. Also, large containers of diesel fuel, of which he had deciphered from the semi. Dealing with this stuff has caused mental fatigue and monetary financial hardship. I suspect that this person's taken other items in the past, such as a GPS system and a generator, which have been missing. Hopefully, the court will hold him responsible for his actions and issue the highest possible sentence. So I want to come back to you, Mr. Simpson, on the issue of restitution here. So if you'll just bear with me, Mr. Schloff has reviewed. I ordered the defendant to undergo a pre-screening and assessment. He did. And I'm going to ask you, Mr. Schloff, are there any material additions, corrections, or deletions in that report?
No, Your Honor.
Anything you would like to say on his behalf?
I would. First of all, I do respect the complainant and his appearance in the statement today in court, but I would ask the court not to consider any speculative charges, either for sentencing purposes or for restitution. Furthermore, Your Honor, my client does tell me that he's employed, and he has a record of more traffic than anything else. Some of it is very old as to more misdemeanors type of thing. What really does strike me, Your Honor, is that if you look from the medications that he's taking, Your Honor, that there is a mental health history as well. And in my dealings with him, I was able to tell that without even looking at type of medication for these. So I would ask the court for a rehabilitative sentence that takes that into consideration, and any other drugs that substance abuse that might be issues for them. Or not to give him any jail sentence, Your Honor. He does live with his mother, takes care of her. Yes. There's that problem with my sick, older mother.
Anything you would like to say, Mr. Gannon?
Yes, sir. The fuel, I don't know if they have cameras that they can pull up, because the fuel was mine. That was in my truck for the week prior to. What else did he say? Like he left 2 boxes.
Well, I can read you the aspect of the report. It says, the suspect had taken a Milwaukee rivet tool, Milwaukee ratchet, drill bits, container with miscellaneous butt connectors, and a black case with miscellaneous cords. All the items were located in the suspect's truck, meaning he did not lose any of those items. And then outside of the above listed trailer, there were multiple items that were behind the trailer that Simpson said were supposed to be inside the trailer. And he goes on to say he was missing fuel from the semi, that there were 6 full fuel containers in the rear of your truck. And Simpson said when he parked the semi, he had approximately half tank, and now had between 1/4 and 1/2 tank. The stolen property was returned to the victim.
The diesel wasn't, because I have no idea why that's even being mentioned. There's no, the diesel was left in my truck as well. I really don't understand.
I was not the original attorney at the time.
Every time I come in, I get a different attorney. That's what we had the problem with last day.
Mr. Simpson, what would you like to say?
I just say that it just that cost me a lot of money. You know, times are hard right now, and then fuel, as high as fuel is for, it's still fuel like that. I know how much fuel I had because I just fueled before I parked my truck. And when
okay, so let me start.
Told me to check it.
Let me start, Mr. Simpson. Let me start with the other items. And by the way, is there a Mark Drabcheck here? He was also a victim on the case. For the record, he did not appear.
I'm still missing items, that I didn't.
Okay, Mr. Simpson, I want you to listen to me a second, please.
Okay.
The Milwaukee rivet tool, Milwaukee ratchet, drill bits, container with miscellaneous butt connectors, and black case with miscellaneous cords. Those were all located in the truck and returned to you, correct?
Correct.
So the only thing that we have, as you said, you were missing fuel from your semi, that there were 6 full fuel containers in the rear of his truck bed, suspect's truck bed. And when he parked the semi, when you parked your semi, you had approximately a half tank and now had between 1/4 and a half a tank. So am I right? You're saying he siphoned out about a 1/4 of a tank. Is that true or false?
That's true.
How much would the value of that be?
Well, they're 150-gallon tanks, so a quarter of 150 give to me what 75-gallon, 40-gallon, 50-gallon. I don't think it. Well, I don't know. I'd have to. Yeah, that'd be exactly.
Not taking these items.
Yes, sir. I know there was a lot of fuel. 6 5-gallon drums. 6 5-gallon tanks in the back of his pickup.
No question to you, yeah, sorry, sir.
Mr. Gannon.
Keep stopping.
How long have you been coming in front of him?
Long, sir.
Why are you continuing to come and see me? Why have you not shown up on your warrants out of out of well, the one that's troubling, in November of 25, a larceny charge. You also got failures to appear on drywall, suspend, show cause hearings, traffic offenses. Why are you not showing up? And you also have a Westland case, failure to appear on a probation violation. I need to know some answers here. Why are you not showing up in court?
Same as it was last time I was in here, Your Honor. I'm just trying to take care of one after the other.
Why do you think that you have the luxury of taking care of one after the other? Listen to me. These warrants have been in effect. You've got warrants outstanding since, a lot of them are from 25. I'll give you that. But you've had the one out of Westland since 24. You don't get the luxury of, well, I'll take care of one case at a time. You get yourself in trouble, you have to appear in court on those cases. You don't get to dictate when you're supposed to show up. I don't know what to do with him, Mr. Slough. I'm going to be perfectly candid with you. I've seen him, and I can't get it. And the probation's recommending just jail sentence. They're not fooling around with you. I just want to make sure I understand. And the drug charge, I mean, what are you fooling around with meth?
I wasn't sure that was found.
On you. Found on you.
Yes, sir. Yes, sir.
What are you carrying around meth if you're not using it?
The container that he claimed, and he says he claimed all of this stuff. He left 2 boxes of the other miscellaneous airlines and Peterbilt floor mats were just on the dirt. And that's the stuff I claimed. He left it in my truck. I still have it till this day. I'm the guy that didn't siphon no fuel out of his truck. That was my fuel.
I'm not talking about the fuel.
No, I'm just
right now. I'm not worried about the fuel. I'm worried about the drugs. Okay.
Yes.
Why are you fooling around with meth?
Yeah.
Well, what do you have meth in your possession for? I took your plea. I would not have taken your plea had you told me it wasn't my methamphetamine. I would have never done it. I know myself. I would have never done that. Not on my worst day.
Well,
did you hear what I said?
Yes. Yes.
So why are you telling me today that you didn't have meth on your person and it wasn't your meth if you told me that day, which I know you would have had to for me to accept the plea, that it was your meth?
My exact words were, before I got to the location, I did not have that on me. The officer he mentioned about taking me for blood work, but then I don't know if he could tell if I was, it's not cited, I can't think of the term, but proved that I've never touched it in my life. But he never took me in for blood work yet.
You said mental health. I don't see any reference to that in this report. So, I mean, you can see kind of with this ADHD, if that's you're referring to.
I'm just talking about the current medication.
I got it. But he hasn't undergone mental health treatment, right? Have you undergone mental health treatment?
Meaning, I have a doctor I see every month for the medications.
What kind of doctor?
It's
see a psychiatrist?
Psychiatrist.
I just don't understand why you're doing this. You've always been respectful. Honestly, I believe a lot of what you're telling me. Because I don't remember seeing you lie to me before. If I do, I forgot about it. And I don't usually forget that kind of thing. But you can't keep going like this.
No.
I'm going to place you on probation on each of these cases for 15 months. I'm going to take your drug case, file C, under section 7411. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance of any unit of the government. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to submit to chemical testing, PBTs, and ETGs on demand of the probation department. So whenever they tell you you have to go, you have to go. You understand that, all of that so far?
Yes, sir.
We just want to check one thing here. I'm going to order that you attend the Positive Strategies program with 8-week follow-up. Positive Strategies program with 8-week follow-up. You're to continue your mental health treatment. Do you understand that? And provide proof of that. Do you understand that?
Yes, sir.
You're to clear all of your warrants. You are to clear all of your warrants within 30 days. Clear all of your warrants within 30 days. All these terms are running concurrent. All these terms are running concurrent, meaning they apply to both cases. Do we understand what I mean?
Yes.
I'm going to need a prosecutorial review date on the C file in a minute here. I'm going to tell you, Heather. I'm also going to order. Ken, did you spend any time in jail on this? You did not, did you?
It was 2 days, or a day and a half, pretty much, but.
In order 12 days jail. I'm going to give you credit for 2.
Would the jail time be at the end of the sentence?
I appreciate your advocacy. He
has to sit right there himself.
He's going now 7 days jail. I'm going to let him do the other 3 on the court work program. You're going to pay $105 for that. I'll attribute that on the B file. You are in custody for 7 days. I'm going to order on fines and costs that you pay fines of $100, and I'm going to go light on your fines and costs. 100 fines, 100 costs, 75 victims' rights, $50 justice assessment. These are all on the B file. 360, 3 1/4, screening fees 60 for 385, probation fees are 300 for 685, court work program fees are 105. Your total 790. On the other case, I'll simply go 100 fines, 100 costs, 75 victims' rights, $50 justice assessment. So you owe 3 1/4 on the drug charge. You owe $790 on the other charge. You are in custody for 7 days. I'm going to let you pay these at the rate of $50 per week, and I'm not going to start this until July the 19th. If you need more time, you'll call me. You'll call the court, or you'll come see me. You're going to pay those on the B file first. And then on the C file, you'll pay $50 weekly after fines costs paid on the B file. Do you understand that?
Yes, sir.
You got warrants out. You're not doing what you're supposed to do. Sir, I can't justify, no disrespect. I cannot justify the restitution. I'm sorry. I really am. I'm not going to order that. I would if there was more significant proof. You could initiate a small claims action or a civil action against him if you choose to, but I just can't do that in this situation. It's too much of a question in my mind. You'll meet with probation, or John, you're going to tell them probation should meet with them in a lockup or wherever, and he is going to go into custody for 7 days. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal if you cannot afford one. You understand that?
Yes.
You need to grow up. You need to grow up. You don't break into cars. You're lucky they only charged you with a 90-day misdemeanor and then gave you an attempt. Have a seat. Thank you.
Judge, we need to do the review date.
Oh, wait a minute. I got to give him a review date on the drug charge. Thank you very much for reminding me. What's the review date, Heather?
That'll be September 16th.
September
I'm sorry.
16th.
I'm sorry, this is a Brownstown. We'll do September 15th.
September 15th of 27 at 8:30. You do everything I've just, listen to me.
Yes.
You do everything I just told you, the case will be dismissed at that time, July 15th at 8:30. Okay? If you violate, you could get 90 days on those. Good luck.
Yes.
Thank you. City of Gibraltar versus John Wood, John Lawrence Wood,
Well,
263-06984.
I'm sorry, what name did you call?
This is not yours. I'm sorry, John Wood. I'm going to get a couple of civil. Thank you very much for coming, Mr. Simpson. I do appreciate it. Thank you. Have a great day. Your name? Did you have insurance at the time of the stop?
No, sir.
Yeah, I can't do this. I'm cutting down for you. I'm not going to dismiss the charge. If you want to set it for hearing or go talk to him again, I just can't justify. This is a 1-year misdemeanor under state law. I'm just not going to do that. If you want to plead responsible to it, you can. If you want to have a hearing, you can. I'll be glad to do either one of those. And I will cut the fines down if you prove to me you have insurance now. Do you want to plead responsible or do you want to have a hearing?
Responsible.
All right. I'm going to accept the plea of responsibility to no insurance. Let me see your insurance, please. Why didn't you have insurance then? Well, you can't do that. I'm telling you, hand that up to me, please. When you have no insurance, you are putting yourself in an awful position. You get involved in an accident. Let me see here. All right, so you went and got it. It looks like
2 days after.
2 days after. All right, I'm going to hand this back to you. I'm going to assess fines and costs of $85, okay?
Yes, sir.
You can go down the hall and take care of that, but don't put yourself in that position, okay? Good luck. Thank you. Zachary Ryan Taylor, 263-07-77. I'm sorry to do this to you. You seem like a nice young man, but I can't change what I've been doing for years. Your name? You're going to plead to 1 to 5 over, right?
Yes.
To that charge, which is 1 point, responsible or not responsible. All right, I'll accept the plea 195. The original charge is dismissed. You are all set. Good luck. Amanda Lynn Raymond, 263-07053. Good morning.
Good morning.
Your name?
Amanda Raymond.
Okay, I'll be glad to set this for hearing for you. Is that what you want?
Yes.
You understand they've got you on radar going 56 and a 45. And listen to me, I'm not trying to talk you out of having the hearing. I could care less. I don't want you to end up with points if you don't need them on your record. You follow me? So it says here they're offering you impeding. You don't want to do that? Let me just explain something to you. If you lose this conviction's going on your record. You're going to be assessed a point, and your insurance is going to go up. If you take the impeding, I'm going to fine you. It's 0 points. It won't go on your record. Now, it's entirely your choice. I am not trying to urge you to take a deal if you don't want. I'm just explaining to you the consequences. Do you understand the consequences? You still want to proceed to the hearing?
Yes.
Okay. We're going to set an informal hearing. Okay.
That will be for July 16th at 9 o'clock.
We can't do it here earlier, can we?
Not really, because then you're off.
How about if I set this for July 2nd? Can we do that?
We could put it on July 2nd.
July 2nd at 8:30 in the morning. Notify the officer, okay? So you're all set. Go down the hall, get your notice, and you will be all set. We'll see you July 2nd. Thank you.
Thank you.
Sorry, Judge, I
Christine.
forgot they're here in the second.
What's that?
I forgot they're here on the second, sorry.
That's okay. Rolando Castillo, 26G307003A and B. Counsel, I don't know what you're here on. I'll be right with you, okay? I promise you. Your name, sir?
Rolando Castillo.
How you doing, Mr. Castillo?
Good, sir. How are you?
Not too bad. Just give me 1 second here. How's your record? Pretty good. But you're going to plead to impeding, right?
Yes.
And then what are they doing with the other one here? Let's see. You read them on two separate. You've got a traffic signal and no insurance, and you're going to plead to impeding, and then they're going to dismiss the no insurance and the traffic signal. True?
Yes.
And you have insurance, right?
Yes.
Yeah, you gotta have that. To the charge of impeding traffic, responsible or not responsible? Plea is accepted. 160. You're all set. Cashier into the home. And I'm dismissing the traffic signal and no insurance. Sergeant, I didn't take that one with where he doesn't have insurance now. What I did is he pled. I told him he could either set it for hearing, and I fined him $85, just so you know.
Okay, should I do that in the future then?
If they didn't have it at all, at the time of the incident, right? Okay?
Yep, thanks.
What do you have, Mr. Rabo?
Your Honor, I'm here on Miss Wilkins, Wilkins. It's a civil infraction.
That's about it, Robert.
Oh, okay. They just brought that in. Give me 1 second. Kimmy Juanita Cheryl, 26B72707A. And then I also have B. You can come up here, Ms. Cheryl. Your name?
Cheryl.
So you had the dog euthanized. All right, so they're just going to go ahead and dismiss these charges because you had the dog euthanized, and there's going to be the possibility of civil litigation for restitution. So I'm going to go ahead and dismiss on motion of the prosecutor files A and B. Okay, you are all set. Good luck. If I put bond conditions in here, will you make sure that they're canceled, please? If I did, I don't know that I did or didn't. Okay. You're all set, ma'am. You can leave the building. Good luck to you. Unless you have something else. You don't have anything else, do you?
No.
Okay. Have a good day. All right. Gretchen Lee Wilkins, 26G307047.
Good morning, Your Honor. Scott Raven on behalf of Miss Wilkins and appearing on her behalf under Michigan Court Rule.
So you're going to plead responsible to impeding traffic on her behalf, and they are going to dismiss the original charge of speeding, true?
That's correct, Your Honor, and I have permission to enter that responsible plea.
To that charge of impeding on her behalf, responsible or not responsible?
Responsible, Your Honor.
I'll accept the plea to impeding. I'll dismiss the 1 to 5 over. Fines cost $170. She can pay by June the 25th. Okay?
June 25th. Thank you, Your Honor. I appreciate it. Have a good day.
Have a good day. Thanks.
Thank you.
All right. Hergard.
Yes, sir.
Michael Stephen Hergard, 26G307078. Your name, sir?
Michael Hergard.
How you doing, Mr. Hergard?
I'm pretty good.
All right, you're going to plead to impeding. They're going to dismiss the original charge, right?
Yeah, is there any way I can keep the fine of 135?
No, I'm going to charge you 150. That's what I do. Actually, impeding on a first offense is 155, but since you've got nothing on your record, I'm going to charge you 150. You still want to plead?
Yes, sir.
To that charge of impeding traffic, responsible or not responsible?
Responsible.
I'll accept the plea, dismiss the speed. 150 is your total. You can go right online today, 33court.com, and make your payment, and you're all set, okay?
I'm sorry, how do I do that?
You can go right on 33court.com with your citation number and make your payment. 33court.com.
All right, thank you.
Have a good day. Advanced
you too.
Underground, 26B150964A and B. No, I cannot and will not do this. I don't know why you guys are, you're sending in the general manager? You own the company? And that's not good enough. You gotta send in the president. If you want to call the president, he can do it by Zoom, but I can't do this. Like, Caitlin, can you come in here? I'm sorry, what, you know where she is? I'll call her. Thanks. Okay. Heather, if anybody ever, hey, Caitlin, can I have you come in here, please? Thanks. I just don't feel comfortable. You're gonna have to get the president on the Zoom. These are not my rules. You know, they're really not my rules. I could make a case that I'm being too lenient here without making the companies hire a lawyer. Now, I bend the rule on a civil infraction, but the president or officer of the company has to appear. So I just can't do it. If it's a misdemeanor, an attorney has to appear. Your name?
Caitlin Foley Carter, President Township.
I just don't feel comfortable with these. So the way I've been doing it, and I'm not going to change, is the president should be the one here, if not a vice president. On a civil infraction, misdemeanors, they have to have a lawyer. Can you call your president and have him get on?
Yeah.
Do it. Give him our Zoom number if you would, and I'll put this aside, have him Zoom in, have her, pardon? Okay, that's fine. Have her Zoom in, but have her identify herself as president of Advanced Underground, and I'll be glad to take it, okay?
Yes.
All right, good enough, thank you.
I come back in here with that, if that's another time.
Come on back in, just to make sure everything goes all right, and we're gonna do it right now. Okay.
I gotta go get my phone.
That's fine. John Michael CTEP, 263-307-076. Mr. CTEP, your name?
John CTEP?
You're going to plead to impeding, true?
Yes, sir.
All right, to that charge, responsible and not responsible?
Responsible.
I'll accept the plea to impeding. 150 is the total. And you are all set.
Thanks.
Down the hall, speeding's dismissed. Good luck. Donna Gale Zamet, 26G307048. Good morning, Ms. Zamet. Your name? You're going to plead to impeding, right? How many times you been to court? Have you ever?
I don't know. Once maybe?
Okay. You look like a deer with headlights on. That's why. With headlights showing in the eyes there. That's why, yes, you're going to plead to impeding, right?
Yes, sir.
Responsible or not responsible? Please accept it. Speed's dismissed. 150 cashier into the hall to your right and you're all set.
Yeah.
I wish you well. Good luck. Malcolm Oatmeal, are you ready? We have to get your lawyer though.
Yes.
Okay, so wait 1 second. Here's what I'm going to do. I'm going to take a 5-minute recess and then I will come back. I will not be longer. I'll be out here by 10:15. If you can tell your lawyers to come on in at 10:15, I'll take them next. Okay, stay seated, everybody.
Yeah. Yes. Me and my daughter, last time we took us together. You know, I did see that on there. Yeah. And I don't believe you. Maybe both just saw the possibility. And what else in the reaction are actually shooting?
Okay. Yeah.
Stuff. So bring on. Yeah. Who's both the signature? Is she gonna be able? Okay. I think the shipping should be. This was in the presentation. Yeah, basically. Another dog? No, it's the same dog. They got, she's the owner. We had to move for Romy. Even we got, we drove. Caitlin, is she around? Other, I need.
All set.
Yeah, just. She does.
And so, jeez, is it hot in here? You hot, Mr. Shaw?
No, it's a matter.
The niece is cold?
Oh, he blames me. I was.
All right, that's fine.
I complained yesterday.
Okay, so what have we got?
We had a.
Is today the 17th or 18th? John, can you take care of that for me? I'm misdating these all day, Heather. So anyway, let me take a look. She's standing mute, waiving formal reading on the B file, and on the A file, she's going to plead as charged. True?
No, she's pleading to the,
No leash.
leak, right, I'm sorry.
Yeah. Is that what you want to do?
Yeah.
To that charge of having a dog with no leash, responsible or not responsible? Please accepted. $135 is your fines. And the animal violation. You've taken good care of the dog, right?
Oh, absolutely.
I mean,
Your Honor, that came up as an issue, but even at that time, my client had gone to the vet, was receiving treatment. We had paperwork to that effect, and I showed the prosecutor why he was of a mind to dismiss it.
I'm just saying, it says animal control officer observed the dog Cooper physical appeared. Convinced, I presume they were trying to say, to be poorly kept and took photos. You're taking care of the dog, right?
Absolutely. I've had this dog for over 5 years.
I'm just telling you what they're saying. I want to make sure the prosecutor must be convinced you are. 135, you can go down the hall and take care of that. Just make sure you're taking care of the dog. Okay, man? Best of luck to you. I wish you well. Have a good day. Good luck.
Thank you.
People against Norkolova, Savara Norkolova. You got it. This is 266-48578.
Good morning, Your Honor. Nick Hanawa appearing on behalf of Mr. Norkolova, Savara Norkolova. P78298, Judge.
How you doing?
Good, Judge. Thank you.
All right. You're standing in for Mr. Sheener, or you're in his office?
Yes, Your Honor. Correct.
Good enough. And this is going to be a plea to what?
Impeding traffic, Your Honor.
All right.
And I do have permission to plead responsible on my client's behalf to that amended charge.
To the charge of impeding traffic, responsible or not responsible?
Responsible, Judge.
So this was a commercial vehicle. They're still doing it $250. Okay. I'll give them a week to pay until June the 25th.
Thank you, Your Honor.
Have a good day. Thank you.
You too. You too. Take care.
All right. All right. Korechik, Tyler Jason Korechik, 23B144140.
Good morning, Judge. Attorney for Westmoreland, appearing on behalf of Tyler Kurjak.
All right, for purposes of arraignment, does he stand mute, waive formal reading?
That's correct, Your
And
Honor.
now there's going to be a plea of guilt to allow an unlicensed driver to drive with the understanding that the drive alone license will be dismissed. True? Is that what you want to do, sir?
Yes.
If you plead guilty to that, this is punishable by up to 500 fines, 90 days jail, costs Geraldo, 0 points. It won't be reported to the Secretary of State. Do you understand that?
Yes, Your Honor.
Did you sign, read, and understand an advice of rights form here today? If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or trial. Do you understand that?
Yes,
The charge allowing an unlicensed driver to drive, how do you plead? Were you in control of a motor vehicle that was being operated in Brownstown on Pennsylvania near Telegraph at 10:12 in the morning on September 21 and 23?
Yes, sir.
Did you allow somebody to drive that was unlicensed, and was that you?
Me.
And are you on probation or parole?
Yes.
Anybody in the world force you to plead guilty?
No.
Please accept it, suspend the drive while unlicensed is dismissed. Why did it take them so long to get here?
Your Honor, he was incarcerated for 2.5 years.
What were you incarcerated for?
Assault battery.
Sounds like it was a little more than assault and battery if you were incarcerated for over 2 years.
Assault battery.
It wasn't assault and battery. They can only give you 93 days on an assault.
Assault battery, yes, I was the first time to stay in Wisconsin. 5 years, I'll get it 2.5 in, 2.5 out.
I'm learning about this outstanding warrant. Came in immediately, took care of it today. As he stands before you, he does have a valid driver's license.
Good. Anything else?
I just asked for cost of
Anything else, sir? No? Hard fines, 150 costs, 75 victims' right, $50 justice assessment, 375 or 60 days. Okay? You can go down the hall and pay that and you're all set?
He'll be taken care of.
Thank you. Johnson Glover, Julian, Enrique, which one's the?
Gannon, I think you were about to call Gannon at one point.
Which one?
Excuse me, not Gannon,
Oatmeal?
Oatmeal.
We'll call him next. Julian Enrique Johnson Glover, 260-1503-74 A, B, and C. Your name, sir? Do you have a lawyer?
Sorry?
Do you have a lawyer today?
I asked for a appointment.
Well, I can give you one. Did you come in front of me?
That's okay.
We haven't been in front of me ever on this case, have you?
It was last year.
Last year, this ticket was issued May 15th.
Yeah, so this is a new ticket I got a month ago, but I was there.
If there was a misunderstanding and you want a lawyer, I would be more than happy to send you to a lawyer. Do you want a lawyer? Yeah. Okay. John, take him to a lawyer, please. People against, give him a defense lawyer. I don't know. Oatmeal, Malcolm Brunel, Oatmeal, the third, 260-150-669, A and B.
James Schwab on behalf of Mr. O'Neill. He's approaching us now.
What's going on there, Mr. Oatmeal? Not bad. Your name? All right. So I agreed to take this under 7411. That was the prosecutor's wish. The defense worked that out. That plea was taken May 21. He was referred for a screening and assessment. If you had a chance to review the report with him, and are there any material additions, corrections, or deletions?
No, you are.
Anything that you would like to say on his behalf?
I'm just asking the board to go along with recommendations.
Anything that you would like to say, Mr. Oatmeal?
Last time we had talked about my medical marijuana license being expired, but it has said.
You felt like you had to go get that?
What's that?
Do you have proof of that?
Yes.
Let me see it.
It's on his phone, Judge.
This doesn't.
This. And
Does it say that?
yes, it does.
Okay, good enough. I trust you. He's going to have to provide proof of that to the probation department. But he didn't spend any time in jail on this, did he? Or did he?
No, sir.
Good. All right. Is there anything else anybody would like to say? You just want me to adopt this, counsel?
Your Honor, about the outpatient substance.
Yeah. I'm with you.
Okay.
I mean, all right. 9-month probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. Kratom poppy seeds and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I will not violate you if you test positive for THC so long as you possess a valid medical marijuana card. So you're going to have to show that to probation. I am taking it under 7411 for 9 months. I'm going to order that you attend the drug intervention and assessment program through PERS. So you're going to attend that through PERS. Also, in order 3 days of community service. I'm going to give you all the way until August the 15th to complete that. Pay fines 100, costs 175, 75 victims' rights fee, $50 justice assessment. So fines and costs are 400, screening fees 60 for 460, probation fees are 180 for 640. I'm going to also, that's it, $40 in attorney fees, total 680. You pay that, you stay out of trouble, you do all these other things, you comply, and I'll be happy to discharge you and dismiss the case on motion of the prosecutor here in 9 months. Can you give me a review hearing date, Heather?
Yes, and Judge, he also has that distracted driving B charge.
Sorry about that. I also have the B file. And actually, I'm gonna assess fines and costs of 175 on that, okay? So 175 fines and costs on that. So it's 175 plus the outstanding fines and costs of 680, was it, or 90? 680, so you owe 855. Do you have all that?
Did he come today?
How much does he have today?
Like 400 of it.
All right, you pay the distracted driving today, okay? That's 175. You pay 2.25 on the drug charge today, and then I'm gonna let you set up your own payment plan, okay? You're gonna tell me how much you can afford. What do you have for me, Heather?
We're gonna do March 17th.
March 17 to 27 at 8:30 will be your review hearing date. Can you pay $50 per week? Okay, you pay $225 on that, 50 a week, starting on, we'll make it June the 26th. If you don't have the money at any time, no problem. Call the court. We'll go on Zoom. I'll be glad to give you an extension. Or you can come in here on or before the due date, 8:30, okay? I do wish you well. Good luck. You're going to meet with probation. Go down and pay your payment and then go over to the probation department. They'll instruct you now. Byron Francis Nowak, file 26B307034. Defendant failed to appear for this department rep hearing. He's responsible as charged by default. Virginia Marie Johnson, 26G3056, 306744.
And good morning, Your Honor. The record change law 30720. Yeah, Miss Johnson.
Good morning, ma'am. Your name?
Virginia Johnson.
All right. Does she stand mute and waive formal reading?
Yes, I've informed her of her rights. And she does stand you wait for a reading.
All right. Does she have any priors?
Perhaps, Your Honor. Yes.
She does it.
After the offense.
2010, she has an impaired retail fraud in 11. All right. And they have a breathalyzer or blood result, one or the other, of 0.17 here. They did not charge it as a super drunk. I'm going to go ahead. You pre-tried it and there's no resolution, right?
Not today.
That's fine.
Although my client wanted to, I'd rather wait until I receive.
Well, you got a good lawyer here. Let him take his time. You don't want to rush through this, okay?
I'm going to ask for some discovery.
Sure.
I'll submit it.
1,000 PR bond. You cannot leave the state without consent of the court or violate a law. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. I do want you going to AA one time per week in person. Every time you go, you have to have the form signed. Every time you come to court, you have to bring the form with you. You're not to have any contact with prosecution witnesses except through your lawyer. Okay, do we understand?
I do have surgery next week.
What's that?
I do have surgery next week.
I think she's trying to explain that you might have to take some drugs.
I understand. Well, nobody's going to stop you from taking the drugs that doctors prescribe. I sincerely wish you well on it, okay? Just make sure you show the probation department the prescriptions and we'll go from there, okay? All right, good luck with that. Wait, well, don't go anywhere. I need to get a court date for you and you're going to get a copy of your bond sheet. What do you have for me, Heather?
July 2nd at 9:30.
July the 2nd of 26 at 9:30. Is that going to give you enough time to recover? I don't need to know that. Okay, good enough. You're all set. Wish you well. Thank you very much. Howard, Ramel Lavertis Howard, Jr., 25 W838526. Mr. Howard, how are you?
I'm doing very much.
Your name?
No.
Did I give you a lawyer yet? I haven't arraigned you on this. Who's your lawyer? Do you know what he looks like?
He just walked out. Mr. Crawford.
Do you know where Mr. Crawford is?
He's New York.
I don't know where in the world he is.
He was in that, that Christmas chamber.
Oh, I see. Maybe this one.
think he has to.
Someone collapsed in the floor. He's not feeding well.
Yes, sir.
Mr. Crawford, I need you in here on, Ramel.
Oh, wait, what's that?
Are you Mr. Crawford?
Oh, this is Vince.
Who? Oh, I know. I'm sorry, Vince. I tried to call him. He didn't answer. Can you get Mr. Crawford in here on Ramel Howard?
You got it, boy.
Thank you. Sorry.
No problem.
Why don't you have a seat right there if you would, okay? People against, who has Thornsberry? People against Johnny Luke Thornsberry, 25 W839-358.
Your Honor, Nikki stayed there. It's not well. And
Your appearance, just tell me your appearance.
James Schloss, on behalf of the
He said that and I offered for him to come back. He said he wanted to get it over. It sounded like, I'll go ahead and adjourn it. Come on up here, Mr. Thornsberry. Hang on, stay right there, Mr. Thornsberry. Stay right there. I'm going to give you a new date. We're going to set this for a revocation hearing. Heather, can you give me a date, please, when Mr. Schloff is here?
Yes, we can do July 2nd at 9:45.
July 2nd at 9:45.
Is that a good date for you, sir? Do you expect to be better?
All right, go down the hall. Have somebody give him the notice. He said he had pneumonia or something. Can you have somebody run out a notice? Have one of the court officers get him out of here, please?
Yes.
July 2nd at 9:45. Okay, thanks. Thanks a lot. People against, who has Amy Diane Brown? 25B149845. A, B. 25B149845C. 25T645864A and B. All right, so what are we doing on this? On the 45A and B, she's pleading to driving on a suspended.
Correct, that's a paraphernalia.
Yeah, but I think there's something wrong here. Hang on. The B file is not drug paraphernalia, it's expired plate.
I think she only has A and C on.
Oh, she has four. Oh, I see. So I'm dismissing the C file. She's pleading on the A file. She's got a contempt hearing on the B file. I hope she has some money. And then on the other two files, 25T645864 A and B, did you pre-try those with Trenton?
One of them is a show cause judge, and the other one is a being fat, it's a year old.
It's a what?
It's a year old.
He doesn't like to show up, huh? Let me take the plea to suspend. If I do that, ma'am, the possible penalties are up to 500 fines, 93 days jail, costs are all those 2 points. I'd take that plea. I'd dismiss the drug paraphernalia for you. Do you understand that?
Yes.
Did you sign, read, and understand and advise the rights form here today?
Yes, it is.
If you plead guilty, you'll be giving up all those rights, and we are not going to have a trial of any kind. Do you understand that? To the charge, driving on a suspended license, how do you plead? Were you operating a motor vehicle in the township of Brownstown, county of Wayne, on King or Club View Court at 12:24 a.m.? And was your license suspended? Are you on probation or parole?
I am now.
Were you on probation on November 23 of 25? Anybody in the world forced you to plead guilty? That plea is accepted. The drug paraphernalia charge is dismissed. I also have an expired plate charge here for which you're in contempt. I have the impeding charge for which there's a contempt hearing again. And then we got a driveway license not valid. We reset a show cause for this. She owes a lot of money on this. When is she going to pay this?
Judge, she's been trying to get her situation taken care of. She's been in rehab since February, and she was just discharged this past May, a month ago. So she's currently moving back with her parents,
Which is in
Belleville.
Do we have your new address?
Yes.
She did update it with the court, yes, when she walked in on the.
Well, when are you going to be able to come with the money on this?
Well, sir, I have a job. So I can start making payments. I'm making payments on my other court case, 100 a month. I can also make another 100 a month here.
Can your parents borrow you, lend you some money?
Yes, they can.
Why don't you try to get some money together? I'll adjourn all of these. I'll set them for sentencing, okay? And we'll go from there. Give me a sentencing date with Mr. Gafe here in about 3 weeks, if you would, Heather.
All right, let me look and see when
Or
he
weeks,
is
whatever.
here. Let's look at when we've got him here. He's here with Judge Hessen on July 8th.
I'm not here.
Oh, wait, that's right. You're off that week.
Judge, I'm here for Judge Hessen on the 22nd.
Of July?
Yeah, oh, yes.
I'm here then, so we could do 8:30, Heather.
Okay, you want to do July 22nd at 8:30?
All of these, July 22nd at 8:30. That will give Ms. Brown time to put her money together, okay? And I'll work with you, but you gotta show me an effort. Congratulations, staying clean. I mean it. Good luck. Thank you. Go down the hall, get your notice. Ramel Lavertis Howard Jr., 25W838526. I'm going to have you call Jessica on this one. All right. Good morning, Mr. Crawford. Your name, sir? What are we going to do on this one?
My client's complete guilty there, for resignation.
Is that right, sir?
Yes.
You plead guilty here. Possible penalties are up to 90 days jail. Do you understand that?
Yes.
And you got to just keep your voice up. So you have here 3 prior technical violations. This would be 2 more. So you understand the possible consequences, correct?
Yes, sir.
All right. And did you sign, read, and understand this advice of rights revocation of probation?
Yes.
You plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
Denise, did you hear me?
Did Judge, but you know what? I didn't catch what file that was.
This is on Ramel Howard.
Howard, thank you.
So as to count 1, that you failed to pay your fines and costs as ordered, how do you plead? I can't hear you.
Good.
Count 2, that you failed to provide proof of completing your 30 hours of community service by May 1, how do you plead?
Yes.
You failed to provide proof of completing your 30 hours of community service by May the 1st?
Yes.
Did you fail to pay your fines and costs as ordered?
Yes.
Anybody force you to plead guilty?
No, Your Honor.
All right, I'm going to accept those 3 guilty pleas. I find the pleas have been made voluntarily and understandingly. Pleas are accepted. I'm troubled by this. I want to tell you. You know, he violated in February. He asked me to convert to community service. I did for him. And I let him, instead of doing a court work program day or something, let him do community service, pay $50 a week starting February 20th, told him to call the court if he didn't have the money. He didn't do his community service that was due on that file on February 20. I told him to have it done by April 1. And he still hasn't paid his fines and costs. He hasn't paid anything as far as I can tell. You want to go to jail today? I mean, if you want, I could just give you 90 days and we'll be done with this. You won't have to worry about 30 hours of community service or paying your fines. You're pretty disrespectful, young man, when I give you a break like that and I tell you to call me if you don't have the money or come in and you do neither and you pay nothing and you don't do your community service. What is the problem? Tell me what the problem is. Can you tell me what the problem is?
I can help you understand what's going on. I think that the court spoke to it a little bit. Bottom line is,
he's immature.
He's a young, immature.
How old is he?
Oh, you're 20.
Yeah, 20.
Does he work?
Your Honor, as the court might be aware, might remember, he's not currently working. He's working as a subcontractor with his father doing landscaping and home improvement. He did hear the court's comments in that regard before that he needs to get on the ball. He wants to be productive, return his life, or he's going to get a job. He asked me going to different places looking for some work, and he has pinned down some work, Your Honor. He's got some work through a temporary agency, I believe. What was the name? BedXL temp agency, Your Honor. He's going to start working June 24th at EOS.
So let me get this straight.
Yes.
He hasn't been working this whole time except sporadically when his dad has a little bit of work.
Well, Your Honor, he has been working as a subcontractor a lot.
How often?
How often do you get out with your dad?
Like 4 or 5 times out of the week.
But it doesn't pay a lot.
Wait a minute, 4 or 5 times out of the week? How many hours per day? Talk to me. Keep your voice up. I can't hardly hear you.
Say like maybe like 4 or 5 hours.
So you're working 16 to 20 hours a week. I can't hear you.
Yes,
How much is he paying you?
It's dependent on the job.
All right. On average, how much do you make in a week?
$500.
$500. Well, why didn't you pay some of your fines?
To be honest with you, Your Honor, I had put some money aside and I had canned.
So you have it now.
My vehicle had broke down.
Why didn't you talk to me? I invited you to talk to me at the time that I sentenced you. I invited you to talk to me at the time of your probation violation. You haven't paid anything. You haven't done your community service. You're working 16 to 20 hours a week. So as far as I'm concerned, you're semi-retired. Congratulations. I don't know how you can do that at 18 or 19 or 20 years old. I commend you for being able to eat, support yourself when you're 20 years old and not working. I mean, I don't understand it. I just don't understand it. You got to get a work ethic, son, or you're going to be in poverty. Mom and dad aren't going to be around to foot the bill the whole time. I don't know what to do with them. I mean, I gave them a break. I converted it. Your name?
Just hold on.
Well, again, you spoke to it. He's been mature to this point and tried to work with him, but I think you might understand it again. At his age, you and this process could be a little intimidating, despite the fact that you spoke to him in plain English, told him to just pick up the phone.
Intimidate.
A lot of folks, again, he said he's trying to save money. He set it off to the side because he wanted to come in one time. And
I know, but I wasn't supposed to. He was only supposed to pay. He was only supposed to pay, and I'm careful of that. That's why I don't have them. I typically don't pay all of it by this date because I know most people can't discipline themselves enough to save. So I said, pay 50 a week.
But again, he was immature. He thought he could discipline himself.
What about the community service? Why didn't he do that? He's got all kinds of time.
Well, Your Honor, he actually has 15 hours of it done. But again, I told him, sir, that's short. It would have been really nice if he came in with the paperwork on letterhead. But he said, hey, I thought I only should bring it in when I got the full 30 hours.
I don't know how frustrating this can be, sir.
Some people are a little slow starters. Give him a kick in the pants.
Well, I mean, the kick in the pants might be something he doesn't want to be kicked with because he might be going in the back of the lockup there.
Not that far.
You don't want to go to the jail, do you? Then why are you fooling around with me? I mean, I got to tell you, so far I give myself a D- on this. If I didn't convey to you I was a lot more serious than you're taking this, then shame on me. I sentenced you initially back October 1st. This is June. You didn't pay any money. Did he pay any money?
As far as I know, he's not getting any money.
And we don't have any proof he did a court work program or community service.
Court work program and his last violation, you converted.
I know. I already said that here before you got in here. What am I supposed to do with him?
My concern, Judge, is that his case was taken under that 771.
Yeah.
His review is technically scheduled for next week, June 24th.
Well, our hope, Your Honor, is that again, he's got some work, so it'll be more regular coming in. He should be able to stick to the payment arrangement. I read in the light act. You're currently in the process of giving it to him, Your Honor, at your level. I think you'd be pleasantly surprised in about 60 days. This has been both taken care of.
Define pleasantly surprised.
Well, that he's gonna come in here with a job and he's gonna have money for you, Your Honor.
How many siblings you have? Are you the oldest, youngest, middle? What are you?
Yeah.
You graduated, right?
Yes.
What do you like to do?
I like to do a lot of things. It just been a hard time, and I know I'm supposed to take care of it.
Find something you really like to do and then do it.
Yeah.
Life is a miserable experience if you're going to work and spending 40 hours a week, which is more waking hours than you probably spend anywhere Monday through Friday with your spouse, girlfriend, boyfriends, whoever we got. If you don't like what you do. What do you think?
At this point, I don't know. I think we've given him a lot of chances.
I know.
At this point, he does have some extra time. We want to keep on to the 771. Technically, a year isn't until October 1.
But again, we haven't made any payments. I don't have proof of the 15 hours that he says he's completed at this point. I had a conversation with him when I issued the violation that he should hurry up and try to get this done before the hearing so that we have some better things to do.
But he didn't do that either.
Yes, again, he's been nothing but respectful to me, other than obviously not completing his costs and things like that, but he does communicate with me.
Heather, when's the review date? June 24th, right?
Let me take a look here, Judge. Yes, that's correct.
Be a date before October 1
For October 1st.
for a review hearing date.
All righty. We could do September 16th or September 30th.
September 16th at 8:30. Sentencing date, give me a date in about 5 weeks, and you're gonna have all your community service done.
Yes, Your Honor.
And you're going to come here with your community service and a good portion, if not all of your funds.
Yes, Your Honor.
Or else you're gonna bring your toothbrush, right?
Yes.
And several clean pair of underwear, right?
Yes.
Okay, good. Give me it in about 5 weeks. That'll give them enough time. If not, I'm not gonna feel bad about cleaning them up.
That'll be July 22nd.
July 22nd. At what time, Heather? At 8:30 is good?
Yes.
8:30 in the morning. Do we understand one another now, young man?
Yes, Your Honor.
So now you have 2 more technical violations. You have 2, you got 5 total. Don't let me down. Don't let yourself down, because you're gonna leave me no choice if you keep playing around like this, okay? Good luck. Thank you. People against David Alexander Potter, 26B150392.
And good morning. Judge, seems like the afternoon. Good morning, Your Honor. Attorney Jeff McCarty, B42633, appearing with behalf of Mr. Potter, seated to my right. Sir, could you please state your name for the record?
David Alexander Potter.
All right, so we can adjourn this to July 2nd.
Well, Judge, I was hoping that we have an implied consent hearing that's related to this on the 13th, July 13th.
Give you July 16th, but if it doesn't resolve, I'm setting it for trial, okay?
That's fair enough, Judge.
July 16th at 8:30, and I'm just gonna mention if not resolved, set trial, all right?
Will do.
Okay, good enough. Anything else, Mr. McCarty?
Just a hello to Mr. Schloff there in the courtroom, and
Mr. Schloff has not been yelling at me today.
well, he's off his game today. He's already in the holiday mood for tomorrow, but I'll see you around on Facebook. Thanks,
Have
guys.
a great day, you guys. Thank you. Take care. Delamarter, Danielle Marie Delamarter, 216-647-570. Good morning, Mr. Holmberg.
Good morning, Your Honor. I'm Holmberg on behalf of the defendant.
Ma'am, your name?
Danielle Delmer.
All right, there was no accident, right?
There was a restitution's been taken care of Bellevue Insurance.
What'd she do?
It's 2 parked cars.
What's that?
There were 2 parked cars that were hit up hooligans.
So they had you, it says the prosecutors reviewed the case, filed charges for reckless but not drunk driving, it says first. Did they have a breathalyzer or blood draw, 6-7?
Right, she was on the limit.
You're gonna be careful, right, young lady?
Yes, sir.
So the charge careless driving, that's what they're giving you, right?
Yes, sir.
To that charge, responsible or not responsible? All right, I'm sure they're doing this for a reason, and I'll accept the plea to careless. That's the reckless, 250 for total. You can down the hall and pay that, and you're all set. Have a good day.
Thank you.
Thank you. Good luck. Be careful, please. Aaron Jordan Kennard, 25G306-491. Is Aaron Joseph Kennard here? Jordan here. Where's your lawyer? Do I have any other files down there, Denise?
I've got some for you, Chairman. Oh, I'm sorry.
Is there a Kiana Bass right here?
Yes.
Ma'am, why don't you have a seat right at that table there, please, until your lawyer comes.
Judge Hudson, right now.
Judge, I have Mr. Farrell's file. He's saying.
Jackson Farrell, 24B82280.
Good morning, Judge. Matthew Gates, on behalf of Mr. Farrell.
Wow. Am I happy? Is everything taken care of?
She said, Caitlin said he was in compliance when they last went up.
Wow. Mr. Farrell, how are you?
Good, you?
Your name?
Jackson Farrell.
You guys, what's your name again, young man? You got everything taken care of, it sounds like. Congratulations. Thank you.
Thank you.
I sincerely wish you well. I really mean it. I'm going to go ahead. So she wants me to dismiss the review hearings up today. Defendant compliant, prosecutor moves to dismiss. I wish you well, Mr. Farrell. I really do. Case dismissed. Good luck to you. Thank you. Have a good day.
Thank you.
Wow, this is very good news for me. Really is. Now what do I have? How you doing, Mr.
I'm good, sir.
Yeah, I hope you're not working tomorrow.
Maybe a little paperwork, but for the most part, no.
Good. People against Dominique Clayton Stone.
You're on
260-645-937.
with the record, James Schlock, 30720. It's my information that Mr. Stone is presently in the Wayne County Jail, out of Southgate. And I spoke to Mr. Bologna about this this morning, first thing. And based on that, based on the nature of the charges and what was going on, I think the people decided to dismiss the case.
Good enough.
Trial in later July as well.
Good enough. Case dismissed. His motion. You're all set. How many days is she serving on the other one?
In
Out of Southgate.
60 days.
Okay, good enough. Case dismissed.
It is a man. He was the person with the.
I'm sorry. Do you have any other cases ready?
I have put up two more on Mr.
Okay.
Bobian and Mr.
Mr. Kennard, I'm sorry, I don't remember who your lawyer is. Mr. Crawford or Mr. Groff? Yeah, we'll get them in here.
Mr. Stuck and Mr. Bobian as well. Did they hand you those files? Or?
I don't have them yet. She's probably.
Over. Judge McNally. 565. Can't believe we ripped through all those cases. I thought it was more closer to 12:30 than, almost a little after 11.
And because of that meeting, we can start till 9:15.
Yeah.
Well, you've been doing this a while, and so have I. James Jordan Bobian, 263-06840. Come on up here, Mr. Bobian.
James Schwab on behalf of Mr. Bobian, 30720.
Mr. Bobian, your name?
James Bobian, Your Honor.
Does he still waive formal reading for purposes of arraignment?
He does, Your Honor.
Now he's going to plead to a civil infraction under Gibraltar Code of Ordinances loitering, right?
Yes, Your Honor.
You guys talk about the fines or anything like that?
We didn't, but we trusted the court to come up with the lowest possible fine possible.
Okay, Mr. Bobian, you understand what your lawyers worked out?
Yes, Your Honor.
This is me a plea to loitering, and they're going to dismiss the disorderly places. You understand that?
Yes, Your
Is
Honor.
that what you want to do?
Yes, Your Honor.
All right, to the charge of loitering, how do you plead? Responsible or not responsible?
Responsible.
All right, so I'm accepting that plea, dismissing the original charge. What were you doing, Mr. Bobian?
Oh, he received a disorderly place.
Yeah.
I was involved in a toxic relationship with two people that didn't get along. It was this
All right, okay.
2 years.
Okay, good.
That is not
She's
she's evicted.
Yeah, she's been evicted and she's moved out.
So you're going to use your brains though, right?
Yes.
Get in trouble. You're a young kid. You don't want to get in trouble. What's that?
I said I need to use better.
I like that. Use better judgment. 150 is your total. Go down the hall and pay that.
Thank you.
You're all,
Thanks, Your Honor.
you're all set. Have a good day.
You too.
Daniel William Stuck, 260-648-067.
Good afternoon, or good morning, James Schlaf, 30720. We have Mr.
How you doing, Mr. Stuck?
He's a little hard of hearing too.
Oh, I kind of remember that. How you doing?
I can hear you. I'm doing good. Thank you.
Can you tell me your name, please?
Thanks, sir.
So you got a good lawyer. He got this negotiated. He says you obtained an endorsement. He got the prosecutor to dismiss. Are you okay with that, or you want to have a trial?
Yeah, he's joking. I got you.
I'm just kidding. Case dismissed. Good luck. You're all set. Have a good day. Thank you.
Take care.
Young lady in the back, what do you have? What's your name?
Victoria Ayala.
What kind of case do you have?
It's a misdemeanor charge for, Oda, leaving the time.
What time was it scheduled?
Tuesday, back. I didn't see it.
That's all right. Set her up with a lawyer. We'll set you up with a lawyer, young lady. We'll give you an advice of rights and set you up with a lawyer.
I do have a question. Did we have a Mr. Walker up today? Bowker?
Did we? Denise?
Larceny.
Yes, we did. He was on for 10:30, James Boker. For
Is he still-
sentencing.
Is he still on?
He was still on the docket for today.
But I don't think he's here, is he?
And that's surprising. No, he moved up north and he has been appearing via Zoom. And the
Yeah, he
board
has.
allowed him the same privilege for today.
I don't
But I
know
am
if there's a phone
surprised.
number in the file or probation.
You wanna
might
call
have a
him?
Phone number.
I'll
I
take
don't
this
have a
Kennard
phone
case
number.
first.
But I,
People, and we're gonna need Jessica on this. People against Aaron Jordan Kennard, 25G306-491.
Morning, Your Honor. My fellow call for Justin today. I'm at station for
All right, so counsel, I arraigned her. She's charged with failure to attend the Retail Fraud and Economic Crime Prevention Program with Class A Training Center and failure to pay fines and costs. And she has, just for the record, she has 8 prior technical violations. So how's she going to proceed?
Well, Your Honor, she can plead guilty to both explanation.
Okay, we'll get the probation officer over here too. Is that what you want to do, young lady?
Yeah.
If you plead guilty, you'll have 10 prior technical violations. You could be incarcerated on this for up to 90 days. Do you understand that? Ma'am, do you understand that?
Yeah.
Did you sign, read, and understand the advice of rights form here?
Yeah.
If you plead guilty, you'll be giving up all those rights and we're not going to have a hearing or a trial. Do you understand that?
Yes.
All right, as to count 1, that you failed to attend the Retail Fraud and Economic Crime Program, how do you plead?
Yes.
Did you fail to attend that program?
Yeah, I did.
Count 2, that you failed to pay your fines and costs as ordered, Dallin Sullivan 230, how do you plead? How do you plead to that, man? I can't hear you.
I'm trying to think about crazy today.
Ma'am, on June 3rd of 2026, did you fail to pay $230?
Yes.
So are you pleading guilty?
Yes.
So the charge you failed to pay your fines and costs as ordered, how do you plead?
Guilty.
You failed to pay as ordered,
Yes.
but you paid it down?
Yes.
Anybody forced you to plead guilty?
No.
And you understand by pleading guilty, your 771 status could be revoked and the conviction entered, and you'd be subject to the 90-day jail term, correct?
Yes.
All right, I'm gonna accept your plea to failure to pay fines and costs and failure to attend the Retail Fraud and Economic Crime Program. Your name?
That's going on.
How many times with her, this young lady, we had to show cause her for failure to attend the Economic Crime Program?
Believe it's been included on all of her show causes. I see, including this one, I have 1, 2, 3,
What is she doing?
these 3. I think we have a total of 4 show causes. I don't think I issued it the first time though.
I think the court is aware this whole thing has been about extreme financial difficulty in Shirani. As the court knows, she has an extremely sick child.
Well, remind me, because you're giving me too much credit. I don't remember
I'm sorry, Your Honor. She has been sick child who's been sick throughout the whole duration of this case, hospitalized up at the U of M Children's Hospital. And
For how long? And when?
In and out throughout this entire time period, correct?
Yeah.
She's just recently been transferred to Ohio. She lives in Ohio.
Right.
You think that's closer, but it's not. It's Columbus, Ohio, which is 3 hours away from where she is. She has to do more driving around. She has limited funds. You know, gas nowadays. It's made it difficult for her to have money to pay. The bottom line is, I want to remind the court that she has indeed paid $230 as of today. The probation department can verify that. My client also has finally been able to put together the $150 for this class, and she would have enrolled, but she told the probation department about that, and it was agreed she should probably wait to see what the court wants to do. The client is taking the initiative to contact the class. It's available. July 17th.
Tell me what's going on with her child.
My daughter had sickle cell and all her organs that failed. All her main organs. So
I'm sorry.
better. But she already
Is the father in her life?
no.
What's he doing?
Until
He doesn't pay child support. He's not in the child's life. You know, I wish when people made choices, women in particular, that they would recognize I just got no respect for men that do that. Non-zero Zippo. You gotta be judgmental. You don't just have kids with somebody that's a deadbeat and somebody that doesn't love their child. Okay. All right. How long is that program again?
It's just one day.
Come on. You're not gonna make me put you in jail because you're not doing the program, are you?
no.
Then listen to my question. Are you or are you not going to make me put you in jail because you refuse to do the program?
I am not.
We're adjourning this case. Give me the same day when Mr. Crawford's here. Will you please?
My report against court that this class isn't until July the 19th.
Yeah, well, I think we're gonna have it. Didn't you give me a date with Mr. Crawford, or was that somebody else for July 22nd?
I'm sorry, July 22nd, Judge, is that what we're looking at?
Yes.
We could do 9 o'clock.
At 9 o'clock. Listen to me. I'm writing down. You know what this is called, right? A highway, right?
Yeah.
Retail fraud program to be completed. I wouldn't miss this anyway, and I will remember this. But if you don't get it done, you're going to jail. Do we understand?
Yes.
And it's not going to be for 3 or 5 days. Do we understand?
Yes.
Do you understand how important it is for you to get the program done?
Yes.
Okay? Please don't disappoint me. I'll set a sentencing date. I'm giving you a personal bond. We're going to redo this have a sentencing July 22nd. Down the hall, get your note. Please make sure you have the program done so I don't have to do something I don't want to do. Good luck. Destiny Cherie Johnson, 260 648 658 A, B, and C. Your name, ma'am?
Destiny Cherie Johnson.
You're charged with driving on a suspended. If you want, I'll give you a lawyer. Do you want a lawyer?
Yes.
You want one?
Oh, yes.
Okay, we'll give you a lawyer. Go out in the hallway, we'll set you up with a lawyer, and then we'll go from there. Thank you. Ma'am, what's your name again? Have you been in front of me today?
No.
Wait, what's her name?
We on the
That's sorry?
Yeah, we didn't get them. Did you need this?
Yeah, yeah. Yeah, you gotta check it out. Come on this way. I didn't see you back, but you got it.
I'm sorry.
Sorry. Oh. What happened today? Yeah, that's the all the prosecutors about not really going.
John. What's her name?
Vassar. She's got a name for flat run. I'm speeding. I love this plan.
If you plead guilty, how long she done default on these? Okay. All right. So I'm gonna set aside the default judgment on the no insurance. That will then be dismissed. If you plead to allowing an unlicensed driver to drive, the possible penalties are up to 500 fines, 90 days jail, costs are all those. And then I will go ahead and accept your plea to defective equipment. Which is added to the no insurance charge, right, counsel?
Correct.
So to the chair, so you understand all your rights, ma'am? Did you sign and read and understand an advice of rights form today?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or trial. Do you understand that?
Yes, sir.
All right, to the charge, allowing an unlicensed driver to drive, how do you plead?
Yes.
Were you in control of a motor vehicle that was being operated on March 21 to 26 of 2012 Buick?
Yes.
Did you allow somebody to drive that was unlicensed, and was that you?
Yes.
Have you on probation or parole?
No.
Anybody force you to plead guilty?
No.
That plea is accepted. And to the defective equipment charge, responsible or not responsible?
Responsible.
I'll accept that plea, accept the plea to allowing an unlicensed driver to drive dismissed, the drive while suspended. And I will also dismiss the no insurance again and accept your plea to defective equipment. I'm ready for sentence. Anything?
Just that Ms. Collins does have a valid license, Judge. She's taking steps to make sure that this doesn't happen again. And she's assured me that she's got everything ordered moving forward.
Good. You got a warrant out of Highland Park. Did you take care of that yet?
Yes.
No, you didn't. It's still on your record. Today's June 18th. It's still on there, a warrant. Is there anything else you want to tell me?
From my understanding, I had paid Highland Park and I had paid 36 District Street.
You better check with them because you got an unregistered vehicle charge out of there, okay?
Yes, sir.
All right. Do you have anything else?
No, sir.
All right. On the unlicensed charge, 100 or allowing unlicensed driver to drive, 100 fines, 70 costs, 75 victims' rights, $50 justice assessment, $295 or 60 days. And I'm on the defective equipment, I'm going to charge you $170. So your total here is $465. Can you pay all that?
We're gonna need it again.
How much do you have today?
She doesn't have anything to take on.
When can she pay this?
She's on a payment plan with Judge Hesson for a similar amount, Judge, I believe $450. That's due in August. And she just paid a bond.
Where does she work and how much does she make?
I work at Hampton Manor. I make $15.50 an hour. My paper is on the 26th. I can use.
You pay the defective equipment by September 1. You pay the allowing unlicensed driver to drive by October 1. If you need more time, do not ignore me. Call the court. We'll go on Zoom. I'll give you an extension, okay?
Thank you.
But don't ignore me. I won't be nice if you do that, all right?
Sir.
Best of luck. Thank you. Johnson Glover, Julian Enrique Johnson Glover, 26P1503744, A, B, and C. And I also have 25F243480.
Morning, Your Honor, Michael Glover. Johnson Glover, so steps to podium station 94 ready. Julian Johnson Glover.
All right, so he has an A, B, and C file. He stands mute on the drive while suspended, does he?
Correct.
And then he's going to plead guilty to the lesser or allowing unlicensed driver to drive. And then they are going to dismiss the drive while suspend, expired plate, and no insurance. True?
That is true, Your Honor.
Is that what you want to do, sir?
Yes.
You plead guilty to allowing an unlicensed driver to drive. I'm going to go ahead and dismiss the original charge of driving on a suspended. I'm also going to dismiss the 2 civil infractions of expired plate and no license. Do you understand that? If you go allow an unlicensed driver to drive, the possible penalties are up to 500 fines, 90 days jail. Costs are all those. If you plead on that, again, I'll dismiss all other charges. Do you understand that?
Yes,
Did you sign, read, and understand an advice of rights form here today?
yes,
If you plead guilty, you'll be giving up all those rights and we're not going to have a hearing or trial. Do you understand that? To the charge of unlicensed driver to drive, how do you plead? Were you in control of a 2009 Dodge that was being operated on May 15 of 26 on Telegraph near King and Brownstown? You allow somebody to drive that was unlicensed, and was that you? And are you on probation or parole? You're on probation to me, right?
so,
You're on probation to me, right?
yes,
You understand by pleading guilty, this would be deemed a violation of that probation for operating while impaired. You could be incarcerated on this charge as a result of that plea and conviction.
yes, sir,
You still wish to plead guilty?
yes, sir,
Anybody know who forced you to plead guilty?
yes, sir.
Somebody forced you to plead guilty?
No, I didn't get,
That's all right.
sir.
I'm going to ask you again. Did somebody force you to plead guilty?
No, sir.
You still wish to plead guilty? I'll accept your plea. I find it to be an accurate plea made voluntarily and understanding that that plea is accepted. I'm going to cover before I sent, and I'm dismissing, of course, the expired plate, the no insurance, and the driving on a suspended. He's got some problems on this other one. What's he going to do on the probation violation?
Your Honor, he's going to be guilty to take responsibility for those with explanation.
If you plead guilty here, sir, since you've absconded, you could get 93 days on that. Do you understand that? And you understand all your rights, so that you have the right to a hearing, right to testify, right to remain silent. You understand all that?
Yes, sir.
Call in somebody for Emily on this, John. If you plead guilty, you're going to be giving up all your rights. You're not going to have a contested hearing. You're giving up your right to cross-examine, to question those guys, to use the subpoena powers of the court to bring in your own witnesses. And we will not have a hearing of any kind then. Do you understand that? All right. Any questions before I ask you how to plead? To the charge, you failed to register for and complete the victim's impact panel. How do you plead? To the charge, you failed to pay fines and costs as ordered. How do you plead? To the charge, you failed to provide proof of completing 16 hours by July 25 of 25. How do you plead? Did you fail to pay your fines and costs as ordered?
Yes.
Did you fail to complete your community service as ordered by July the 15th or July the 25th of 25?
Yes.
Did you fail to register for and attend the victim's impact panel?
Yes.
Anybody in this world force you to plead guilty?
Yes, sir.
And accept your plea to that charge. I'm going to get the probation officer in here. I'm going to sentence him on the allowing unlicensed driver to drive. Probation's on their way. What would you like to say, Mr. Crawford?
Well, Your Honor, the reason my client has struggled so with that patient is that he suddenly had a really big life change during the course of this, really unfortunate. He was evicted, Your Honor. He had no place to stay for an extended period of time. He was unhoused. He also lost his job. So he's really been struggling. And just in the midst of all of this here, survival became a little bit more important than these matters, even though he could have addressed these anyway in that circumstance. But he is happy and proud to be able to report to the court that he has finally found some work. He's looks like he's going to be starting pretty soon with 4. He showed me the acceptance letter. And he's been able to work with his family, his mother's here in the courtroom, kind of pull some money together, Your Honor. The court might notice there's a $1,000 bond there that the family put together. They've given permission for it to be applied to fines and costs that's necessary under the probation violation, Your Honor. He'll have a few bucks, so we can go ahead and.
It's a third party poster.
Pardon me?
That's a third party poster.
We did receive a phone call from a Kimberly Johnson who was giving permission to apply that bond.
So again, he's got some support, so he can adequately address this because he's getting back on his feet, Your Honor.
Hang on. The phone has got to go out of the building. Phone out of the building. I don't understand how that happens all the time. You know that? We got signs all over. Common courtesy to begin with. Your name?
Elizabeth Commissioner.
Go ahead.
He's also happy to report that, again, with the support of his family, he's got some money here today where he's ready to start paying fines and costs for us to get rid of the initial matter. And so he's ready to take this on, Your Honor. If there's some time where the court can give him an additional month, he'd be able to take care of the community service and victims impact panel. Things are really looking up for him.
What do you have to say, sir? Anything?
take full accountability of my actions. Like I said, like you said, this case, OWI really put me.
I gave you the biggest break in the world. You know that?
You did, sir.
2 days community service.
I know.
Attend the victim's impact. I find you. I didn't put you on probation. I didn't make you test. I didn't make you do court work. I made you do nothing. And then you blow it off?
I didn't blow it off.
You blew it off.
Well, Your Honor, I mean, having no home, no car, no job, not really going off the circumstances, here impossibility.
Where does he live now? Where does he?
I live with friends and family, like boxing.
He's still in the house.
Why? How old are you?
32.
Why are you not working? You're not disabled in any way, right?
No, I'm not. I'm just trying to find work. Like,
come on. You're not. Did you graduate high school?
Yeah.
You're not a convicted felon, right?
No.
Don't tell me you can't find work.
I'm saying I've been.
No, I don't believe you. I'm sorry. I just don't believe you. Unless you're applying to be, the president of University of Michigan or something. I just don't believe that you've been applying to work and not been able to find work to the point that you're displaced. I just will not believe it. There's too many jobs. I see now hiring all over the place still.
Well, Your Honor, what my client helped explain to me, and I think the court understands, without a car, it comes pretty hard.
You can't have a car if you don't have money. You can't have money if you don't work. I mean, it's really simple.
But he's fighting his way through this circumstance. And the point is, he does have a job lined up now, Your Honor. He's got some family support. He can get from point A to point B. So he's not disagreeing with what you're saying, but he's in a different place than when this started, this rolled downhill. He appreciates the limited activity that the court asked him for the probation. He doesn't deny that he's fortunate, but he wasn't in a position to deal with it. Now he is.
No, you didn't put me to sleep. I just hear these same stories about these same guys every single day. And it's just kind of like, really? I mean, it just gets tiring. I know you're doing your job and you're doing a great job for them. But we put ourselves in bad positions. You put yourself in a bad position because you weren't motivated. Nobody's going to convince me otherwise. I don't care if you have
motivated. Me trying to find a job, I feel like this case, it's been like a downfall for me. I can't even, I feel like.
Because you didn't want to do 16 hours of community service and you didn't want to do a one-night victims impact panel.
I did want to.
Ms. Wiles, what do you have to say?
I don't know if I can, I was going to indicate the same thing. I mean, obviously he was sentenced in May, no probation.
I know.
Very generous to the court and zero communication. Ms. Tessino was his probation officer at the time, mailed out that court date. He could have came in and talked to you at his court date. He could have done community service, walkable, bikeable places, nonprofit. He gets to choose. Again, I know, in my opinion, I'm with you, Judge, he just ignored the court. I don't know if he thought it'd go away or fix it later. I understand what counsel's saying, but there are some things he could have done on this. He could have came to court. He could have communicated with Emily. He could have completed those community service hours. Again, it's been, 13 months. He could have came in today with it done.
And
nothing else to add, Your Honor. He's just hoping for the opportunity to show you in a short 30 days, he can get all of this resolved. He's got money for you today. 30 days can take care of it.
First of all, on the allowing unlicensed driver to drive and assess fines in the amount of $100, costs of $200, 75 Vicki Bryce $50 justice assessment, 4.25, or 90 days. On the other one, the drunk driving, I don't know what to do with you, frankly. I mean, I could cut you a break because the statute makes clear if you don't think they're coming back, you're not supposed to place people on probation. That's the law. I follow the law. Probation is, there is no probation. There is no probation.
Would you extend sentencing to give an opportunity to show you can do these things? The remaining 2 items.
Who's the CEO right now, Heather? Can you tell me?
I'm sorry, Judge, what was that?
How much, how, can you tell me how much, Mr. I know it was 9.25. I don't know if there's other late fees,
Oh,
Mr.
yeah.
Johnson, whoever owes.
On the OWVI, he has a balance of $1,264 after late fees. And there's a suspension on there too.
It's just hard for me to imagine why you're doing this to yourself, to be honest. I can't reiterate that enough. You're to pay $1,000 and serve 5 days on the court work program and pay $175 in court work program fees or serve 90 days. Defendant to pay right now $1,000. So I'm going to take off that 2.25 or whatever else he owes. Defendant to pay $175 by July 15th and serve 5 days court work program, again, or serve 90 days. Do you understand that?
Sorry.
On the other case, I will let you pay $50 per week. I'm talking about on the driver and the allowing licensed driver to drive, you pay $50 per week. I'll start this beginning on August what's the first Friday in August, Heather?
Let me take a look here, Judge. That is August 7th.
And if you pay $50 weekly beginning August 6th. And if you do that, great. You can serve your 5 days on court work, great. But if you miss one, or you don't serve them, you're going to do 90 days. You have 21 days to appeal and 14 days to apply for a court-appointed lawyer for purposes of appeal. Still a gift.
Thank you.
I can't imagine you continuing to do this to yourself. Good luck.
Did you say I'm sorry, Judge, did you say to remove that late fee on his?
Yeah, yes, I'm gonna remove the late fees too. I know. I'm gonna send him a Christmas card and a birthday cake too.
Thank you, sir.
Destiny Cherie Johnson, 260-648-658 A, B, and C. Is she here?
It's not in the hallway building.
What would the people be doing?
Robert, you see Ms. Johnson's out there.
Yes, sir.
Francisco Elijah Cantu. 25 F244762A. Was this defendant supposed to, it just, I see never zoomed in as written.
No, he didn't zoom in.
Correct, Judge. I never canceled the warrant. I don't on counties like that I've never dealt with. So his warrant still stands. They never zoomed in with him.
I didn't have a bond on him. He's just there on another case. Is that what's going on?
Correct. He gets out, I believe, tomorrow from that, so he can just turn himself in.
Reschedule, please.
Okay.
Thank you. Victoria Renee Ayala Roque, 26F246190.
Good morning, James Schloff, 30720.
Your name, ma'am?
Victoria Ayala.
She waives the formal reading of the warrant your honor stands being.
I'm entering a not guilty plea. Does she have any priors?
Yes, Your Honor.
21, you got one?
Yes.
Are you off probation on that, I presume?
Yes, Your Honor.
Can you tell me what the breathalyzer blood result was, you know?
I've not seen any discovery. It's a flat case.
How old are you?
27 next month, so 26.
This is not good. $1,000 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed, no marijuana, no illegal drugs, no illegal controlled substances, no contact with prosecution witnesses except through your lawyer. You have a warrant out of Wyandotte or Riverview too. You're to attend AA, NA 3 times a week. I won't make you do a sober link device, but you're going to do that. We're going to give you a new court date. So he's going to hand you a form. You have to go in person, okay?
Yes.
In person. And I'm going to give you a court date, and you're going to have to fill out a petition for a court-appointed lawyer if you want one going forward. Where do you work at, ma'am?
One Star Bar.
That's not good. Do you do a waitress or something?
Yes, sir.
Why don't you find another job? I'm just telling you. Give me a date if you would, Heather, please.
Okay, this is a Flat Rock case, Judge.
July 2nd?
That would be Judge Heston's day if we want to cross over, or we have Flat
Let's
Rock.
do the other. I'll just do the next one. Is it the 16th?
We have the 14th. We can do 1 PM.
But I take it that's not my day.
I don't think so.
No, that's an add-on. That's an add-on docket that we actually need to find an attorney.
July 14th at 1, okay?
Put a discovery order in there, though.
I signed it.
Okay.
I'm sorry.
So whoever is on that date.
Right, exactly.
Cover.
Okay? Good luck to you. Thank you. Do I have Johnson here?
I see her here.
Destiny Cherie Johnson, 260-648-658A, B, and C. Ma'am, your name?
Bethany Johnson.
Did you meet with a lawyer yet?
No, I was
So
waiting.
get me the file.
I was waiting in the hallway for one.
That's okay. Here's what I'm going to do if it's okay. I can go ahead and, it's 12 o'clock. Can I just go ahead and arraign you? I'll give you a personal bond and I'll give you another court date. Is that all right with you?
Okay.
Is that okay? I mean,
I'm honestly not really sure that I can talk to her.
well, listen, I'm going to go ahead and arraign you. I promise you I'm giving you a personal bond. I'm not going to make you post anymore. Okay? And then I'll reschedule it and we'll give you a lawyer when you come back. Fair enough? So you're alleged to have operated a motor vehicle, you think you did it, with a suspended license on Western Westfield and Trenton, May 26 at 9:20 PM. They think you had a suspended license. That is a misdemeanor. It is punishable by up to $500 fines, 93 days jail, costs or all those in 2 points. You understand that? Did you sign, read, and understand this advice of rights form here to do? If you plead guilty, you'll be giving up all those rights and we're not going to have a hearing or a trial. Do you understand that? All right. So you have the right to a lawyer. I'm going to enter a not guilty plea. I'm going to let you go out. I'm going to give you an adjournment. I'm giving you a personal bond of $500. You don't have to post any money. So either way, we're giving this defendant a lawyer, Heather. Okay? I'll just make a note. Got late in the morning. And you should go out if you can and don't tell me if you did or didn't or admit that you did or didn't. You should go out and try to get a valid plate and valid insurance before you come back. Okay? You don't have to wait. Okay, so you can show that to the prosecutor, show it to your lawyer when you return, okay? We'll give you another date. What do you have? Is this going to be what, July, what?
This could be July 2nd at 10 o'clock.
At 10 a.m. Is that okay with
Actually,
you?
you know what, Judge, do you want to do her right off the bat at 8:30?
Yeah,
Or should I
since
do-
she was waiting. Is that all right with you? We'll take you first. Make sure you give her a lawyer though, Heather. Note that in here. We'll give her the lawyer right away, okay?
Okay, Judge.
Good luck.
Thank you. Have a great
It's
day.
nice to see you smiling. Nice to see somebody smiling besides me, right? That's a smile. Vassar. Kiana Victoria Vassar, 23F241410A. And I have a B, and that's it.
James Schlock, 30726.
She's going to plead your name? She's going to plead the no ops on person, and then they're going to dismiss the suspend, but they're going to keep in effect the default judgment on the avoid traffic control.
I took a dog, a puppy.
Store was open to the public at the time?
Yes, Your Honor.
You didn't have anybody's permission to take that puppy, did you?
No.
And this was a puppy they had offered for sale?
No.
Why'd you take the puppy?
I wanted to replace my daughter's puppy that had recently got stolen. Okay.
And this was 3 days before Christmas. How old's your daughter?
She's 3.
At the time, was she 2? Or and ma'am, I do have to advise you, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yeah, sure.
Counselor, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from people?
None from defense, Your Honor.
Have I complied with the court rule?
Yes, Your Honor.
Second, really?
Yes, Judge, we are satisfied.
All right. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be before me on
July 22nd at 9 a.m.
July 22nd, 2026, 9 a.m. Bond will continue. And Ms. Wyman, could you? Yes, be. All right. You'll be before me. You can stop down at my probation department right down the hallway on the left-hand side. So we'll get it started, okay?
Okay, thank you.
You're welcome, man.
Thank you, Your Honor.
Court calls the case, People versus Merrick Lincecum.
I know it. And right here. Assistant Public Defender Chinazi Carey, I can rule, Your Honor, on behalf of Merrick Lincecum. Merrick, state your record.
Merrick Lincecum, good morning, Your Honor. Good morning, sir. I have before me a plea form that indicates the defendant will be pleading no contest to an added count 3 of retail fraud, 2nd degree, the 1-year offense. Upon his successful plea to that charge, counts 1 and 2 would be dismissed. Defendant agrees to pay full restitution at the time of sentencing. That's the court's full understanding.
That is correct, Your Honor. So you understand?
Yes. May I have him sworn?
Raise your right hand. Solemnly swear and affirm that the testimony you're about to give to the court is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
And now state your name for the record.
Eric Clayton, let's go. Sir, it is this court's understanding that you're going to be pleading no contest to the charge of retail fraud, 2nd degree. That is a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that? Sure. You also understand, do you understand what a no contest plea is? Yes. 2 things about it I have to make sure that you understand. The first is that it means that you're not further desirous or wanting to contest this charge. You understand that? The second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? Sure. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court. I'm sorry. Basis for the no contest plea?
Potential civil liability, Your Honor.
Sir, to that charge, how do you plead? No contest. Now, you understand that by pleading no contest, you'll not have a trial of any kind. So, signed in advice of rights form, is that correct? Any question regarding those rights? No, Your Honor. Please look at paragraph 5 on the podium. Those are your rights which are part of a trial. And by pleading no contest, you're giving up those rights as well as all the rights on that form. Understand. understand you're giving up your right to appeal of right. Understand? Are you on probation or parole?
Yes.
You're on probation or parole at the time of this?
No, this is from 2023, I believe, right?
Yes.
Well, I was not. I was on probation a little bit after, like, but
Okay, but not at the time. All right, thanks. Has anybody promised you anything other than what's been stated here today to get you to please?
No.
Did anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
No.
All right. The court has been handed and has reviewed Washington County Sheriff's Office report for their case number 23-53023. Any objection to the court reviewing that report?
None from defense, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, I understand.
All right. Counsel, you're aware of any other promises, threats, or other inducements which have led to this plea?
None, Judge.
And have I complied with the court rule?
Defense is satisfied.
Court will accept the no contest plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 1483 probation. Sentencing will be
July 6th at 9 a.m.
July 6, 2026, 9 a.m. before Judge Freshour. Bond continued. Thank you.
Oh, here, Don continues on.
Court calls the case of People versus Robin Hardy.
That's the balance of people.
Good morning, Your Honor. Ashley Hannibal for Robin Hardy, requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Stephanie Cannon.
Where's Ken? Ain't paying attention. Thanks. Drop your bags, you're still at least. Permission to practice is granted.
All right. We're just requesting an adjournment today. I'm just requesting an adjournment today for the negotiation.
Do you hear? Ms. Hardy?
Yes, I'm here. I'm trying to get the camera to work.
Okay. Yeah, my Cannon's cases.
Okay.
Okay, there you are. State your name.
Robin Hardy.
All right. You're requesting an adjournment.
Yes, Your Honor.
Probable cause conference will be adjourned July 9th, 2020.
Thank you, Your Honor.
Thank you, Your Honor.
Bond continued.
Thank you.
Court calls the cases of the People versus Michael Moore.
Your Honor, Raymond Cook for the People.
Billy Gaines, Assistant Public Defender, with and on behalf of Mr. Moore.
On all 6. Yes.
Please state your name.
Michael Moore.
Your Honor, we are in the process of negotiations. We just recently received the mitigation letter from, as in this week, received the mitigation letter for us to present to the prosecutor. So we're asking for a short adjournment, maybe 2 weeks, so that we can continue negotiations. And we'd also like to address bond for one of the
cases?
One of the cases, Your Honor. For all of the cases except for 26 F5-5051, Mr. Moore has a bond of 1,010%. We're asking for a 1,010% bond on that matter as well. If the court would permit that bond, Mr. Moore is stating that he believes he would be able to post all of the bonds and get himself into a substance abuse treatment program. That we have been working diligently to get him in that. There's already a release to treatment on all of the cases. We are working to try to get his holds in Dearborn cleared up. He was able to get one. There's one more that we're still working on that has been a bit more challenging, but he would be able to go to treatment. Your Honor was able to do that.
I'll adjourn all of these to July 2nd. Do the people have anything they want to say regarding bond?
Maybe Roach, because I have something that I think addresses both the adjournment as well as the bond.
All right. Yes. Will be denied in that case. Court will continue the bond as set. I will adjourn all of these to the 2nd. 9 a.m. Thank you.
All right, thank you.
All right, thank you. Court calls case People versus Dean Hodder.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Hodder, Your Honor.
He was what?
What's just a courtroom? I just saw him. Oh. You know what I mean? We pass this matter. Perhaps he's in the restroom. I mean, he was in here.
Over at community.
He was here. Yeah,
Sure.
long beard. Yeah.
So if he doesn't show up, you can go into custody? Yeah, okay. I'll pass it. Yeah. It's probably Bellinger. I'll pass it. What are they doing?
Wait, can I see what the next case was, please?
So we can go look for him, Your Honor.
Not telling. Court calls case People versus Lee, Pat.
And that connect with people, Your Honor.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Patton, who's making his way to the podium, Judge.
Public defenders doesn't take bindage like 3. That's blue. Anyways, your name, sir?
DeAndre Fed.
Thank you. What are we doing?
And we're asking for a brief adjournment in this matter to review discovery as well as discuss potential next steps with Mr. Patton. The people have made a waiver offer regarding a potential sentencing issue that they're agreeing to keep that open.
Correct me.
July 2nd, 2026, 9 a.m. Bond continues.
Thank you, Your Honor. All right.
Court calls the case of the People versus Daniel Healy.
Oh, the people.
Michael Gaddy, Assistant Public Defender on behalf of
Your name?
Daniel Healy, sir.
Take your hands out of your pockets, please. What are we doing?
Your Honor, we're asking for a brief adjournment to continue plea discussions with the people.
July 9th.
I support receiving the bond violation report. Find the progress report was done to change the defendant's most recent constitution positive for an ATG.
Yes, it does. You been drinking?
Yes, Your Honor.
You're not supposed to be kept Did you see it?
Yes, Your Honor, I have had a chance to see the report. I too interpreted the positive for ETG not to mean that he actually just took a test, but that it came back positive for alcohol. Mr. Heelan does, well, as he just told you, he did drink. He is working. He has a prescription for the other substance that was indicated. He is working to make positive change. We'd ask the court to consider his unequivocal and honest response to the court in regards to the violation, and perhaps give him an opportunity to continue testing, remain outside of custody, and continue dealing with these matters.
You completed Bear River?
Yes, Your Honor. You know, I know I'm stuck. I've still made a lot of progress, Your Honor, and I'm not making any excuses, but I'm not using much worse things and doing much worse things. And again, not making excuses. I've just been going through it. I'm still waiting on my place. I'm just right there, and I just got changes on the way. I'm going through it, Your Honor. Again, not making excuses. I own my actions.
I think he is in line for a voucher or a subsidized housing unit, Your Honor. We thought it was going to be North Manor, but it appears it'll be Arbordale now. But he is
where?
Arbordale.
There was a clerical error, Your Honor.
No, I got it.
Your Honor, we've been here a few times over the last month or so. It looks like on 5/14, my notes indicate he had not been going to community corrections. He was ordered to appear in person, and then we understood that he was testing at home division, but those results were not being released to community corrections.
Right.
Then on the 21st, we're back again. The home division results were supposed to have been sent over. I asked for a test that day, but the defendant had no money to test. The court was very sensitive to the housing needs of the defendant and did not want to mess those up. So the court allowed him to stay at liberty. The concern of the people now is that we haven't really had any. The tests that we've had since Bear River have just been since the 21st of May. We do have this positive alcohol test, and as sensitive as I am to the defendant's need to secure his housing voucher, the concerns I have are the support that he's getting. It seems like it's not a sufficient level of support to keep them from drinking or using drugs. So I am concerned about his ability to remain compliant with his bond conditions.
Your Honor, he is, as indicated, is working with Home and New Vision according to the bond report. It appears that Home and New Vision has released the results to Mr. Heelan, and those have been sent over. I didn't quite understand the language in the bond a report that they will have to apparently go through. The way I read it was they'd have to go through Home and New Vision to him to community corrections. I don't know if that in fact is the case. I don't know if they would perhaps agree to release them to me so I can send them along. But that was a bit of an unusual circumstance when I read it, and I got it yesterday afternoon, so I didn't really have a chance to follow through.
I tried to get them released there, so I'm trying. It's a headache. I'm trying to get them to just straight release them all.
How often have you been drinking?
Not often, Your Honor. That was actually just.
Well, no. Listen. How often are you drinking?
Not often, like a couple of times, period. Like, I'm not a big drinker, Your Honor. I'm trying, Your Honor. I'm trying so hard. I just going through it. It was a 1-year anniversary of my father passing, and I'm not making excuses. I went off the hinges a little bit, but I'm trying to keep moving forward. Again, I haven't gone back to the worst things, and I'm proud of myself for that, but I was very disappointed in myself.
What type of treatments? You're at Home and New Vision. What type of programming are you in over there?
Intensive outpatient. I see Elizabeth Aoki. specializes in intensive outpatient treatment. I just really started with her. I'm just.
How often are you seeing her?
Once a week, sir.
Anything else during the week?
I've been attending some meetings. I'm trying to find some.
How many supposed to attend?
I mean, I don't have a supposed to, but I should be going to one.
You want to stay sober.
At least.
How many meetings should you be attending?
At least one a day, sir.
And how many meetings have you been attending?
About one every 3.
So bottom line is you're not doing the stuff to even help yourself right now.
I need to step it up. I need to step it up.
So if you've been doing this, tell me why I shouldn't put you in jail today.
It'd be counterproductive for me just going to jail.
Well, what you're doing is your life is counterproductive right now.
Still making some positive progression. I am making positive progress and I'm trying hard.
Where's your housing thing right now?
I'm right there. I've just did the new referral packet. There was a clerical error. They didn't have units available, so I kind of had to start over, but I'm right there. Like within the next week or 2, I'm going to have my own place. For the first time in a long time.
You know, we don't. You don't get that housing, that's going to be an absolute disaster for you, isn't it?
Yes, Your Honor.
Even more so than what you're doing with your life right now.
So bad, you know. I just want my own place so much. I'll be able to work. I'd be able to take showers and actually be able to function. Just want my own place so bad.
Why are you messing it up?
That's $1 million question, Your Honor. But the flip side of that is I know it's a mess up and I am honestly reconciled with myself and I'm trying. And I've talked to Elizabeth. I'd like to start seeing her twice a week, but there's a full schedule. That's right now. She just got to work that in. And I really do know that I've got to step it up and I'm willing to do that. The reason I haven't been going to any meetings, honestly, I don't have a lot of transportation and I don't.
You can walk to a meeting. There are meetings all over. You can walk to a meeting.
Well, I'm trying to find.
I'm not
new one.
I am not going to even hear that. Because you know that's not true. You can walk to a meeting. There are meetings going on all over the place. Here's what I'm going to do. In order to defendant is to report over to community corrections placement on Scram Tavern.
Thank you, Your Honor.
And I want you to get a sign-up sheet and have it filled out that you've attended an AA meeting every day from today forward to the adjourn date. You're to bring that with you to your adjourn date. I want to see it. Follow me? Miss a day, I'm putting you in. Comes back, take your hands out of your pockets. You miss one, I'm putting you in. I'm not even listening to any excuse as to why you didn't get there.
Sure.
If it comes back with any alcohol in your system, you're going. I'm just going to let you know how I'm going to handle it. Because I'm not sure I should be giving you this chance.
Thank you, Your Honor.
During this to July 2nd, 2026, 9 a.m.
To report to community corrections right now, Your Honor.
Yes, he needs to report right now. Don't leave here without going over.
Sure.
I have given him instructions.
Thank you, Your Honor.
Thank you, Your Honor.
Courthouse case, People versus Kenneth Perry.
Kennedy, Your Honor.
Good morning, Your Honor. Ashley Hannibal for Mr. Perry.
Your name?
Kenneth Perry.
What are we doing?
We'd like to set a preliminary exam.
Discovery is complete.
Yes, Your Honor.
You will have the witnesses available the 30th. Preliminary examination will be set June 30th, 2026, 9 a.m. before Judge Washington.
Great, thank you.
Courthouse case, People versus George Henderson.
Amazon on behalf of the people, Your Honor.
Public defender, not Carrie, I can review, Your Honor, on behalf of Mr. George Henderson. Mr. Henderson, state your name, for the record, please.
George Henderson. Thank you.
1 second, yes.
Really? What are we doing?
Judge, we are setting this, nope, we are asking for an adjournment.
What? You don't, what are you doing? Setting it for?
Setting it for an adjournment.
Sir, you're okay. You're fine. What do you want me to do with?
I got a green sheet, Judge. We want to set it, we want to adjourn this now. No, thank you.
Sir, want to adjourn your man? Huh?
Have contact with Mr. Henderson, try.
Don't try to blame Mr.
I'm not. Right. Go ahead, what you in?
It's not your fault. it is all her, right? Yeah. Okay, remember that. Yep. He threw you right under the bus. July 9th.
Thank you, Judge. Okay, I'm gonna talk to you.
Krista. Yeah, thank you. Said it. Calls the case of People versus Arnold Preston.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Preston. Would you please state your name, sir?
Arnold Preston.
Your Honor, we are requesting an adjournment. There is some outstanding discovery forensic interview. We'd also like to address that.
How long will that part of the discovery will it take to get to them?
I sent a signed executive order to Your Honor this morning, so
We sign up.
We have not.
We have not yet.
validate some more, I would assume early next.
All right. Then I'll adjourn the matter to July 2nd, 2026, 9 a.m. Esteban.
Your Honor, Mr. Preston works for Edge Facilities. He's worked at that specific location for years. He's worked for the family of companies a total of 3 years. He's the night shift supervisor. He he is in danger of losing his employment, and he is asking that the court consider that and grant him a personal recognizance bond. He indicates that he would follow any orders of the court, including any orders regarding contact or any other things that the court might think were appropriate to assure his presence. He is originally from Michigan. He did spend some time in Indiana, which is where the his children involved in this matter live, but he does have ties here in Michigan. And again, he's working, and this is where he's originally from. He has his mother and other family here.
From the people.
Your Honor, this is, at this time, I would object to any modification in bond. This is a criminal civil conduct matter concerning two other defendants, minor children. And although they were some time ago, the defendant does have 2 previous CSC convictions on his record.
Thank you.
So given that information, given the defendants, of course, would have intimate knowledge of where the victims are. Just litigation things of that nature. Checks to modification.
Motion for bond modification is denied. Bond will continue.
Thank you.
Hey,
Anything else?
Court calls case versus the Peter Beisha.
An assistant public defendant, Nick Berkovich, on behalf of Mr. Avesha, who should be appearing via Zoom. I believe he is under the Motorola.
What?
He should be under the Motorola.
That him?
If you remember, Your Honor, yesterday we had a similar issue.
Yes, we did.
Hello.
Hello, state your name.
My name Peter Iveza, Your Honor.
Okay. You don't have a camera, do you?
I do have camera, but doesn't know work. I don't know to work with this one. I see you guys, all of them pictures and report, but I see you guys, but
oh, we got you. We got you. We can see you now.
All right.
Your Honor,
better than what we did yesterday.
Yeah, we have made progress since yesterday, Your Honor. As indicated on the green sheet, I would be requesting an adjournment to have him work with my mitigation team to make a mitigation with court to provide to the prosecution.
When did we adjourn his case yesterday? You didn't?
I believe it was the 15th, Your Honor.
15th. Okay. Then let me do this because the day-to-day seem back-to-back days work for him. I'll adjourn this out to July 16th, 2026, 9 a.m. Bond continues.
Thank you so much, Your Honor.
Thank you.
Your Honor.
Take care.
Thank you so much. Bye-bye.
You're welcome. Take care.
Bye.
Bye-bye. Wait, Lisa. Wow. Okay, there you go. Okay. Let's get busy. Court calls case People versus Martez Richard.
Oh. Public Defender Jay Bellinger on behalf of Mr. Richard, who approaches.
Decided to do something today. Oh, I just said, never mind, my bad.
I Huckleberry fend my cases out, Your Honor. That means if you get them to think that painting the fence is a lot of fun, then you get them to go on the record for you. Great.
Sir, what's your name?
Martez Richard.
Thank you. What are we doing?
Your Honor, I am seeking to set this matter for preliminary examination today, and then I would ask to address the bond, both cases.
All right. Preliminary examination in these matters will be discovery is complete.
To the best of my knowledge.
People have their witnesses available the 30th. June 30th, 2026, 9 a.m. before Judge Barr. As to bond.
As to bond, Your Honor, we would respectfully request that Mr. Richard be released on a PR bond subject to any reasonable conditions the court deems appropriate, including a GPS tether. Mr. Richard, from my understanding, had an initial failure to appear, which we'd argue was not the conduct of a willful disregard for this court's authority. At the time, he was homeless and did not receive notice of the court date. Since then, his circumstances have significantly changed, and he has taken significant steps to stabilize his life. He just completed substance abuse treatment, has been accepted into a sober living program where he now has stable housing in Ypsilanti. He also has reliable transportation through the sober living facility, eliminating many of the barriers that previously contributed to his instability in that regard. In addition, he also has significant family responsibilities. He's the caretaker of his disabled mother and recently welcomed a newborn into the world. A newborn, unfortunately, he has not been able to meet yet. He recently suffered a devastating loss, that of his brother, who passed away a few weeks ago as well, Your Honor. And so in addressing any concern related to public safety, he's fully willing to be placed on a GPS tether, comply with any additional bond conditions the court believes is appropriate. He's willing to utilize third parties for any necessary child exchanges, ensuring that there is unnecessary contact related to this matter, and fully understands the no contact order that's in effect. So we would respectfully be asking you to consider, please, a conditional release on a GPS tether and any other appropriate conditions that you might deem necessary.
So I'm going to object. According to my notes, failed to appear back in March of 2025. At the time of this failure to appear, he was present in court. The people brought up bond violations at the time for calling, texting, trying to connect with the victim on Facebook. And after the court passed the case for us to try to get a report from YPD, when it was recalled, he had left. So I have concerns that he was present, heard about violating bond at the time, failed to appear, and was not back around until this year. I would have concerns that he comes back to court and his ability to follow court orders, especially given that it took him so long to come back, knowing he had left court against court orders. It was my recollection as I handled that case that day that the court was very clear that he needed to be at the courthouse and not. So I would have concerns. It would be objective.
How did he come into custody from the warrant?
I turned myself over to the police when they tried to get me.
Your Honor, my client advises that he turned himself over to the police. How did that happen?
Yeah, it was. I was at. Want to tell him to.
You're at what?
Want to tell him to.
Yeah, you can tell him.
I was at the library when they approached me. They asked me my name and everything. And I told them my name, and I told them.
You didn't go to the police and turn yourself in.
I think he's arguing, Your Honor, that he didn't resist arrest at the time.
I will.
But that would have just been an additional charge.
Understood.
All right. I mean, but he didn't go knowing that he had a warrant. He didn't go turn himself in. That's what I mean.
I was just now getting stable, and I'm back stable now, Your Honor.
And I think part of the problem at the time, Your Honor, was that was the fact that he was without a home and didn't have a lot of notice in that regard. We had issues with contact early on as well.
And I just want to see my daughter. I haven't saw her since she was born because I was in here.
I understand that, sir, but
I will come back.
Well, but you didn't before. That's the problem. And so I don't know that I can trust you to come back because I passed it so that you could talk to your attorney. I recall and get a cogent argument as to the bond violations, and then you just took off and didn't come back. Doesn't work that way. Motion for bond reduction is denied. Bond will continue as is. And after exam, maybe who's that before?
Judge Barr.
Barr will feel differently.
Okay.
All right. All right. Thank you.
We will address it before Judge Barr.
Courthouse case versus Curtis Jackson.
Morning, Your Honor. Raymond Cook for the people.
Assistant Public Defender Davi Leba for Mr. Jackson, who is on Zoom.
State your name.
Curtis Jackson.
And Your Honor, I did have some conversations with Jackson yesterday. He's indicated he'd like some more time to consider his options if requesting a brief adjournment.
Adjourn it to July 9th, 2026, 9 a.m.
Thank you, Your Honor.
Court calls. Well, yeah. Sharp is it? Oh, there it is. Court calls the case People versus David Sharp.
Joy Gaines, Senior Assistant Public Defender, with it on behalf of Mr. Sharp.
State your name, sir.
David Warren Sharp.
Thank you. What are we doing?
Your Honor, we're asking for an adjournment. We requested some additional video discovery.
During the matter, will that be available soon? July 2nd, 2026, 9 a.m. Bond continue. Thank you.
Thank you.
Court calls case People versus Eric Jackson.
That's all this.
I got to keep her mind on the charge.
Yeah. Okay.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Jackson. Would you please state your name?
Jackson.
Your Honor, Mr. Jackson has been working with our AIM division and had an appointment with the Middleton specialist that he had to reschedule. We're requesting a 2 to 3 week adjournment so that we can get that letter done.
July 9th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Bond continue. Court does call the case People first, Taiwan Grid.
At the bottom of the people matters. But the issue.
Who?
Actually, I can really understanding in for Miss Stephanie Cannon who stepped outside. Mr. Your name for the record.
Taiwan Griggs.
Judge, I don't know if the court is in receipt of the documentation
The
corrected.
yes, we have it. All right, and I believe she wanted. Well, she's here now. Finally.
I'm sorry, I was in the booth with Mr. Briggs. My apologies. We are asking that the 24 case be set for a preliminary exam. The prosecutor is working on discovery as to the 25th case, and the amended information or the amended forensic order is in with the court.
Oh, the 24 case you want set for exam, discovery is complete in that one.
Yes.
And people have their witnesses available the 30th.
I have not checked that case, but we'll try.
All right. So the 24 case that will be set for preliminary examination on 30th, 2026. 9 a.m. for Judge Washington. The other matter, what's the timeline on discovery?
I think it's either going over today or it went over yesterday. So very
okay. And then I'll set that one. I'll adjourn the probable cause conference to July 2nd, 2026, 9 a.m.
Thank you, Your Honor. My client is asking that he allowed to be released to the care and custody of his sister on tether. She is trying to, she was his guardian. She's not his guardian anymore, but she is accepting him back to the house. He does want to go back into inpatient treatment. The court has signed an order allowing that. His Wayne County was his Wayne County hold was cleared. They gave him a PR bond in that matter. And he has the paperwork to show the PR bond. He wants to go home. He has health care. He has SSD, I believe. So he has the ability to get into treatment. So he's asking that he be allowed to be released as well. And he'll go directly into treatment once he wants to take care of a few things. To be clear, he discussed his personal care. He's very, he wants to get that together. There's things that he discussed with me, Your Honor.
Yeah, I've been addressed on several times on cases. I will note just, if I recall correctly, the court did grant the police treatment for the people's objection, which is fine. But I will also note, and I think it's worth considering by the court, that the defendant did get the 2025 resisting and obstructing case the day after we missed court on the 2024 assaulting, resisting, or obstructing case. I think that if it's going to be anywhere that's not in custody, would need to be at a treatment facility because he doesn't appear to be able to remain law-abiding when he's out on his own.
I'm going to, at this point, as I have before, deny the request for bond. Bond will continue in both matters.
Thank you, Your Honor.
So, can I ask a question? So this
I would be released to treatment then?
No, the release to treatment is still in place. If treatment's available, if they get it bad, you'll be released to treatment.
Yeah, they told me that it'd be anywhere between this time and Monday, you know, that, but
If it happens, then it will happen. But
It's the court understands that you have been, he just wants the court to know that he has been screened and in bed is available by Monday, he hopes.
yeah, then if that happens, then he can go. I did that over the people's objections because the reality, Mr. Graves, that's what you need. You need treatment.
Thank you.
And so I'm willing to allow the release under those circumstances so you can get the help you need.
I comprehend.
And Your Honor, depending on the length of that program, if he is released on Monday, with our examination being on the 30th,
Right.
I'm not sure whether or not he'll be available to come. So if defense counsel gets any information about that, they could let us know. So call us.
Right, and get that moved.
Yes.
Right. Thank you.
Information for me.
Court calls the case, people versus Roderick Jacob